Yes.
To take it to item number 30, my lord.
30.
My lord. I have taken consent paper after this.
On a prayer made on behalf of the respondents, list after 2 weeks. 30. Yes. No, what that?
May I please? For listing of it, second appeal.
Oh, which year? Which year?
This year, you.
No, a new matter, fresh matter.
New press matter.
Okay, when do you want? When did you file?
12th year.
When did you file?
I have filed in the month of April and it was listed on 22nd April. Year.
Then what had happened?
Then something mistake is there because of that I took that.
Okay, you have rectified?
Yes.
Okay, we'll have it.
All right.
Fresh matter, we'll have it. Okay. Mr. Sakya, you be here, we'll upgrade your matter.
Yes,
Yesterday we tried to finish it off. Mr. Senso, I think, is there.
my lord.
We'll finish the matter immediately. Just a minute. কালি যে এটা হেৰিয়ে মাৰিছিল যশোধীৰৰ মেটাৰ এটা হেৰিয়ে মাৰিছিলে আমাৰ বিপ্লৱে তাৰ এটা কপি এটা আনি দিয়েছে আছে আনিছে ওকে এখন কি এখন কি এখন কি তলত না ক্যালেন্ডারখন কি দিছে এখন ইয়াতে লগত আহিছে এটা নটা থৈ দিও You just we're just finishing off your matter. Just have a look, make the corrections, let me dispose of. Both of you have a look, make corrections with pencil. Item number
60 supplement.
60 dispose of, huh? Did you? Yes.
Please, Your Lordship. Our Lordship, I am praying for listing of the IA Lordship in RSA.
IA for
IA for Lordship restraining the appellant to construct any building in
injunction
injunction.
in RSA.
In RSA of 17 Lordship, they have started constructing building just recently.
Okay. When did you file the IA?
On IA on 16/5 Lordship.
When
It
did
has numbered Lordship.
Okay, not listed.
Not listed.
Okay, we'll have
Next week.
Okay.
Deeply.
May I please, Lordship, with the consent of the other party, Lordship, I beg to mention item number 26, Lordship.
26 years.
Can this may be adjourned for 2 weeks, Lordship?
Okay. For the petitioner.
I'm for the respondent number 3.
I am for the
Okay, respond number 3. Okay. On a prayer made on behalf of the respond number 3, matter is adjourned by
2 weeks. Lordship.
2 weeks.
my lord.
2 weeks. 26, 2 weeks.
All right.
Yes.
I beg to mention for listing of case, my lord, 23 matters. Last May it listed CRPIO. So, if your lordship permitted to order it come to the Lozima, my lord, otherwise not listed.
Now, what is the stage now?
My
Service
lord,
is complete.
After motion stage, 4 weeks was granted but not listed, my lord. We have taken state. So,
Okay.
Lozima says that if permission that they have incur.
The returnable period is over.
Yes,
Returnable period is over.
over.
Okay.
Last year also.
Okay, we'll have it. Why Lozima is insisting? Yes, 4 weeks, yes.
Okay.
When, Mr. Borwa?
Your lordship, any confidence next week?
Okay, next week, next Friday.
Next, right. Obliged.
Please, my lord, I beg to mention item number 41, my
4-1, yes.
My lord, in this case, my lord, respondent has filed two IAs, my lord. I pray for 2 weeks time for filing my objection in the IA.
IA for?
There are 2 IAs, one for adding one party, and my lord, another is for.
You'd like to file your objection?
Yes, my lord. I have taken the consent from Mr. BD.
Sri A.K. Gupta, learned counsel for the respondent opposite parties.
I'm for the appellant.
You're for the opposite party appellant. How many? One?
Yes, ma'am.
No, more than one.
IA 2 IA.
No. Your clients,
Two.
opposite parties, appellants, pray for, and is granted 2 weeks time to file objections in these 2 Is. Common order, huh? List after 2 weeks.
Okay.
May I please, Your
This is 41.
Yes.
Lordship, I beg to mention for.
Is there any interim protection till now?
My lord, IA already disposed of.
Okay.
Disposed.
for listing a miscase in MSc AP. It was last listed in
Case
2017.
for,
MSc AP, condonation.
case for condonation,
Condonation.
IA, not miscase.
No, in 2015. It was
15,
mis-
okay, it was miscase. 15 matter, okay, we'll have it next week.
May I please report? Your Lordship, I beg to mention item number 29 on the daily list.
Yes, please.
Your Lordship, the arguing counsel is traveling overseas, and I've obtained the consent of the other side. The matter may be adjourned for the day and fixed on the 19th of June if permissible
Here for the petitioner.
for the petitioner.
We can't give a date on your mentioning. We'll adjourn it by 3 weeks.
Yes.
On a prayer, the learned counsel for the petitioner prays for an adjournment on personal grounds, full stop, list after 3 weeks. 3 weeks is okay for,
Your Lordship your Lordship may have it before the 24th of June because the trial court matter is listed on.
you're seeking an adjournment. Today is what?
Today is the 7th.
7th. Listed after 2 weeks. Okay,
May I please report? In item number 10 and 11, matter,
yes.
the lordship appeared for one of the applicant.
Oh, yes, those matters. Okay, 10 and 11, please before any other bench. Without
May-
me.
May I please tell that?
Yes.
I beg to mention for listing a review application.
A review.
Yes.
In a writ petition.
Well,
In a writ
in
petition.
a writ petition.
What was the order?
I am the respondent, well, sole respondent.
Okay.
Order was that the direction was given to offer appointment to the respondent, madam. But subsequently, we have filed the contempt, and thereafter, after 2 years, review petition has been filed.
Oh, you are the respondent in the,
So, yes,
who has filed the review?
review filed the central
State.
government. Yes,
State?
Yes.
State or central government?
well,
Central government?
central government,
CRP?
CRP,
Okay.
SSC.
Yes, by this court.
Yes,
Order
by
was by this
by
court.
this court, madam.
We'll have it
Well,
converted.
may it be taken upon 20th month, June,
Thursday,
20 June, madam.
Thursday, no, have it on 19th.
19th. Month.
Or have it on 20th. We'll try
Yes.
to finish it off.
Yes,
2-0.
That's why, madam.
Okay.
Month.
Yes, Mr. Das.
Yes, please, your Lordship. Lordship, back to mention item now 49, your Lordship.
Yes.
I need an accommodation for today, Lordship. I have some personal issue. I have to travel, Lordship.
49.
49, Lordship. It has come for the first time, your Lordship.
Okay.
I'm just
49.
accommodation for today, your Lordship.
On a prayer made on behalf of the
Appellant, Lord.
appellant. List after a week.
Lordship. Much obliged, Lord.
May it please your Lordship, I am praying for listing of one RSA, Lordship. It was last posted on 1/6/2022. Thereafter, it has not been listed.
RSA which year?
2013, Lord.
13. Okay, we'll have it.
On
Next.
any date in the next
Yes.
month.
Don't give Tuesday. Give on Wednesday.
Lord.
Okay.
May it please your Lordship, I beg to mention item number 7.
Yes.
Lordship, the senior is out of town. Please list it after 2 weeks.
Item 7. Matter of which year?
But I have not seen the list.
Matter of which year? Check the list. 2 decades. 2004 matter.
Yes, Lordship.
It is for orders. We are not adjourning. We'll see. We'll let the matter reach.
So, Lordship, the
For
senior is out.
personal inconvenience, 1 day maximum. We'll see. Have to see the file. Not now. Be there.
Please, your Lordship. Lordship, I pray for listing of one RSA 2017 matter, your Lordship, for orders, your Lordship. We have already informed the other side. We are for the respondent. One respondent has expired, your Lordship, and they have not yet filed any application yet, your Lordship. It has already a bit. So it may come up for orders next week. Your Lordship.
Last listed when?
Last it was listed on April, your Lordship. I don't remember the date exactly.
I don't think we don't find the RSA which year? 17. Okay. Have it on not 7th. Have it on 18th or 19th of June.
May I please, your Lordship? Lordship, I'm mentioning for IA to be listed on Monday
IA for
for conversion of CRP into second appeal. As the matter has been below, title execution is listed on 11th of June in the lower court.
Can you convert the CRP into a second appeal?
Lordship.
You can't. You can convert an appeal to a revision. Where are your substantial grounds? Where is the court fee? You can't. The other way it is possible. Revision, the rigors is not there. But see, appeal is a creation of the statute in a prescribed procedure. You consider, and you need to withdraw the revision. With a liberty, will grant you liberty. We can consider your IA and grant you liberty, but you cannot convert. Okay. Have you done Monday? It may not be possible. Kali khula nahi kya, amar? Kali khula nahi kya? Monday will not be possible. Wednesday.
Lordship, on Tuesday, it is listed in the lower court below.
We can't help. And if we, even if we convert it, can we pass any orders? We cannot. You seek an adjournment in the lower court. Wednesday, you make a prayer. Okay.
Oblige your Lordship.
Please, your Lordship,
Yes.
I'd like to mention for item number 10,
10 years.
sorry, 9.
9 years.
Yeah. Senior is out of station for medical purpose of his wife,
Who is your senior?
L. Gogoy.
Okay. 17 matter. Other side has appeared,
No other side. There's
not
no,
appeared.
there's no other.
It is for orders.
Yes, Lord.
Why is it for orders? Let us see. Why is it for orders? We'll accommodate you, but it may be for steps. Let us see. Okay.
Okay.
Be here when the
Obliged,
matter is called. Yes.
Lordship, this is application under section 24 of CPC Lordship for transferring FT civil case from 190/2024 in the Court of Principal Judge Family Court, Kapru Metro at Guwahati to the Court of Learned District Judge Dibrugarh Lordship. I am the wife of the respondent Lordship.
From Guwahati to Dibrugarh.
Yes, Lordship. I am the wife of the respondent Lordship. I was married to the respondent on 30/4/2021.
The petitioner is the wife.
Yes, Lordship. I was married.
Petitioner second party.
Yes, Lord.
Second party wife.
Yes, Lord.
And the proceeding is for?
Lordship.
The proceeding before the trial court is for?
Lordship, a notice has been issued on 7/3/2000.
Proceeding is for what?
Lordship, my husband filed divorce.
Divorce
petition.
proceeding.
Yes,
Tell us that.
Lordship. And notice was issued on 7/3/2024 to me, Lordship.
Yes.
Tomorrow is the date, Lordship.
Okay.
Yes, date, Lord.
What are your grounds? Why do you want to transfer to Dibrugarh?
Lordship, my financial condition is not good, Lordship. And I'm independent, Lordship, to my elder sister. I'm staying with my elder sister.
Where?
Dibrugarh, Lordship.
First you say that
Yes, Lord.
petitioner stays at Dibrugarh.
Yes, Lord.
Where was the marriage?
Lordship, Dibrugarh, Lord.
Marriage was at Dibrugarh.
Lordship, Tinsukia, Lordship. Tinsukia.
The matrimonial home was at Guwahati.
No, Lordship, Tinsukia.
Matrimonial home.
Lordship, Tinsukia.
You stayed after marriage at Tinsukia.
No, Lordship. Lordship, I was married to 30/4/2021. Then, Lordship, my husband brought me from Tinsukia to Guwahati, Lordship.
That is matrimonial home was at Guwahati.
No, Lord, his home is not there. Lord.
You live together as husband and wife. Where? That is the matrimonial home. Please try to understand, madam. Just don't come to the court like this. If you don't even understand what is a matrimonial home,
Okay.
we are not here to discourage you, but you should know what are the minimum meaning of a matrimonial home.
Yes,
You're
Lord.
saying Tinsukia. Where did you live together? Last,
Lordship, Guwahati, Lord.
Guwahati. Then why did you leave Guwahati for Dibrugarh?
Lordship. Yeah. Lordship, because Lordship, Lordship,
What are the grounds of divorce?
Lordship, my financial condition is
What
not
are the grounds of divorce?
because Lordship, I have filed 2 petitions in Dibrugarh, Lordship. Two cases are pending in Dibrugarh, Lordship.
For
One case is for domestic violence, Lordship, and one case for
Lordship complaint case for Sweden Lordship, which is pending in Dibrugarh Lordship.
You are asking back your Sridhan and you are opposing the divorce. What is this?
Lordship, my husband filed divorce petition Lordship.
What are the grounds of divorce? What are asking you?
Lordship, his main intention was harassing me, that's why he has filed
Madam,
divorce petition.
what are the grounds he has projected for divorce? Are these questions irrelevant or relevant? We don't think that these questions are irrelevant. You do not even know what are the grounds of divorce. You are not prepared. What are the grounds? How did it happen? Why did you have to, was you made to leave Guwahati for Dibrugarh? You come prepared at 2 o'clock. 2 o'clock. Come prepared, not like this.
Highly operative.
My lord, I have been affected by an execution of a decree. My lord.
Who are you?
I am the person, my lord, who was not included in the original suit,
Petitioner, not party.
not part,
Not party in the suit.
not part in the suit.
Then decree for?
Decree for execution of execution of a title suit, my lord.
No, decree for what?
That decree for right title interest of a land, my lord.
Yes. Okay. Then it
Then,
was,
my
it
lord,
was put to execution.
put to execution now.
Okay.
And now at the time of execution, I got to know about that decree.
Yes.
Accordingly, my lord, I filed MJ case before the learned executing court. My lord, under order 21 rule 96
96.
to
Okay.
stay the execution.
Okay.
But the accordingly, my lord, on the first date, it was stayed. However, on the subsequently, on 14/11/2023, my MJ case was rejected.
Page.
The impugned order, my lord, impugned on page 73.
<clears throat> 70.
73, the impugned order.
73. Page 73. Date 14/11.
14/11/2023.
Okay. Yes, 14/11. Please read.
So, my lord, since if the decree is executed, then I will be severely affected. My residential land, my ancestral land will be gone. So,
Now,
my lord,
what is, let us read the order.
yes, my lord, order. May I read, my
Please.
both sides are represented. Peruse the case record. Perusal of the case record shows that the petitioner paid to stay the proceeding of the title execution number 3/22 till the disposal of the TS number 235/22 by petition number 1334/22 under order 21/026/97/98 read with section 151 of CPC dated 7/9/2022 on the ground that TS 48/1998 is fraudulent. Perusal of the case record also shows that the petitioner also filed petition number 1509/23 under section 10 and 12, during section 12 of the CPC to pass necessary orders. In the paragraph number 12, 13, 14, and 15 of the 16 of the petition number 133/22, the petitioner pleaded that Hafizuddin Ahmed filed PS number 43/1998, which was decreed ex parte. Then title appeal number 36/25, 2005 was filed by the defendant number 4 Gyasuddin, which was also dismissed. Then legal heirs of the defendant number 4 Gyasuddin filed RSA number 103/2009 before the Honorable High Court, and the appeal was dismissed. Thereafter, the title execution case number 3/22 is filed, and during the pendency, the petitioner filed case number 235/22 for right title and interest. Now, whether the petitioner has right title and interest over the suit land, that will be decided in PS number 235/22. Until then, I am not inclined to stay the proceeding of the title execution case number 3/22, as the decree holder got the opportunity, the enjoyment of the decree after a long period since 1998. Hence, petition number /134/22 is rejected. Regarding petition number 1509/23 under Section 10 and 12, redo Section 12 of the CPC, it is to be mentioned here that petition number 1334 is filed to stay the proceeding of title execution number so and so, and not for right title interest. Hence, petition number 1509/23 is rejected. So, my lord, on the face of that record, my lord, one mistake committed by the learned executing court, then the decree holder enjoying the decree since 1998. However, decree was passed on 2005. Right? So this is a wrong, my lord, committed. And also, my lord, here in this case, the executing court admitted that my right title interest will be decided on PS number, which I have filed for that particular land where we are going to execute. So it is admitted that it will be decided. However, if the executing court, the decree will be executed, I will be vanished, my lord. My restitution will be
You had filed a separate title suit.
title suit. My lord.
Is it required? First, number one question. Is it required? Can you go for a multiplicity of proceedings? What is the meaning of the provisions of law which you have invoked in this petition? Kindly read 101, Order 21.
This is right, my lord. Order 101, Order 21, Rule 101. Then third party proceeding can be initiated before the land executing court. This is one of remedy.
Please read it.
Yes, my lord.
Whenever a third party is affected by a decree, he has been given recourse to law by means of these particular sections. And one of the provision is 101.
101, yeah.
Order 21, Rule 101. Please read.
All questions, including questions relating to right, title, or interest in the property arising between the parties to a proceeding on an application under Rule 97 or Rule 99, or the representatives and relevant to the adjudication of the application shall be determined by the court dealing with the application and not by a
separate suit. On your own volition, you had filed a separate suit. What wrong has been committed by the executing court? You espouse your cause in the separate suit, file an injunction application, get an injunction.
So, my lord, my submission here. At the
We have taken recourse to two. You have taken a chance. Either in the execution court I succeed, or in the suit. Suit, you are not being able to get an injunction. Get an injunction.
So,
if you have a good case.
So, my lord, I have a remedy under Order 21, Rule 101. Then that I may be off, my.
It is not a remedy. It is almost a bar. It's not a remedy. Remedy you have already chosen by filing this application. Under Order 21, Rule 97.
The Rule 97 for stay of suit. Stay of the decree, my lord. Rule 97 stay of the decree.
What about 99?
I have gone for Rule 97, my lord.
Yes.
Rule 97 for stay of suit.
Yes.
So,
Please read.
Order 20.
Please read.
Resistance or obstruction to possession of immovable property.
Yes.
Where the holder of a decree for the possession of immovable property,
Yes.
or the purchaser of any such property sold in execution.
And
of a
come to
decree
101.
is the
Isn't 101 to be read along with 97? What is 101? 101 is the procedure laid down that all questions arising out of a petition under Order 21, Rule 97 will be decided by the same court, executing court, and for that no separate suit is required.
So, my lord, my submission here, my lord.
At best,
I may be allowed, my
at
lord,
best notice, at best.
my lord, my
We
kindly,
don't find
my lord,
any.
kindly bear with me.
Yes.
My residential will be destroyed, land will be destroyed, man. Kindly bear with me. I may be allowed to file a petition under.
Your
21
residential residence will be destroyed by this order of 14/11/2023.
My
And
lord.
you have filed this revision when? When have you filed?
My lord,
When have you filed? Answer us.
on 31/5.
4th of June, it has been reported. You could wait for 6 months and you are making a hurry today that tomorrow is going
My
to be
lord,
destroyed.
my lord, now I have got to know that it will be, I will be evicted. Earlier, I was in illusion that I was instructed by my lawyer that will be sold by the executing court. Now, my lord, my lord, my client cannot know about that, whether I will be instructed by my advocates, my counsel. So if the eviction will be done, my lord, what will be the other remedy available? My humble submission, my lord, I may be allowed to, at the present
So
stage.
are you submitting that no eviction can be done in spite of a
At
decree?
present stage, my lord, only some days may be granted. I may take the recourse of order 21 rule now 101.
Sorry. We are dismissing this.
My lord,
Heard.
my kindly bear with me, my lord.
We have heard you in length.
I will take the recourse of 101, my lord.
You are not supposed to take a recourse. 101 is the procedure laid down. You have filed your suit. Your conduct is very clear. You have tried your luck in both the forums. Heard free. H.R. Chaudhary, Learned Counsel for the petitioner who has filed this application under Article 227.
My lord, I'm sorry, my lord. I would like to place a judgment, my lord. The Sikkim High Court judgment.
Which High Court?
Sikkim High Court.
What is it? What is it?
In the same proceeding, in the same way, my lord, that was stayed, my lord, order 21 rule 97.
We can stay it, provided the facts justify.
So in the same course of
We'll
action, my
consider.
lord, that was stayed, my lord.
Article 227 of the Constitution of India, read with Section 151 of the CPC. Full stop. Para. CPC, in which challenge has been made to an order dated 14/11/2023 passed by the learned Munsif number 2, Nagaon, in MJ case number 151 of 2022, arising out of title execution 03 of 2022, full stop, by the aforesaid order, comma, the petition has been rejected. Full stop, para. The facts projected in this petition are that title execution case 3 of 2022 has been instituted for has been instituted with regard to a judgment and decree dated so and so. Full stop. The said judgment and decree was the subject matter of challenge in appeal, including second appeal before this court. Full stop. It was thereafter that the execution proceeding was initiated. Full stop. It is contended that the present petitioner was not a party to the suit, and accordingly he had filed the application under Order 21, Rule 97 of the CPC.
Rule 26, 97, 98, and 151. Rule order 21, Rule 26,
Rule 26,
97,
97,
98,
98,
Read with section 151 of CPC.
read with section 151 of the CPC, which was registered as miscase number, with the miscase number 151 of 2022. Full stop. It is submitted that though initially there was an interim stay, comma, wide the impugned order dated 14/11/2023, the said MJ 151 of 2022 has been dismissed. Full stop. Para. The learned counsel for the petitioner has submitted that the suit land consists of his residential house, and in the event the execution is affected, comma, irreparable loss and injury would be caused by him, and therefore he prays for intervention with the impugned order dated 14/11/2023. Full stop. The learned counsel has also relied upon a decision of the Honorable Sikkim High Court dated 25/8/2023, passed in WPC 37 of 2017, wherein and has contended that under similar circumstance, comma, relief was granted. Full stop. Para. The submissions advanced have been duly considered. Full stop. Para. Perusal of the impugned order dated 14/11/2023 would, however, reveal that apart from taking recourse of the aforesaid provision of law by instituting MZ 151 of 2022, comma, the petitioner has also filed title suit 235 of 2022. Full stop. The provisions of law contained in Order 21, Rule 101 is very clear, which prescribes that all questions arising between the parties in a proceeding in an application under Rule 97 or Rule 1999 shall be determined by the court dealing with the application and not by a separate suit for the purpose. A separate suit, full stop. It appears that the petitioner had chosen to file an independent suit as mentioned above, being title suit 235 of 2022. Full stop. It is seen that the impugned that the learned Munsif had taken into consideration the aforesaid fact of filing of an independent suit wherein the petitioner would have all the rights to pray for an injunction, which perhaps he had done and was not successful. Full stop. Para. The jurisdiction conferred or exercised under Article 227 of the Constitution of India is a supervisory jurisdiction wherein this court is to supervise whether the orders passed by the subordinate court is in accordance with law and within the jurisdiction conferred. Full stop. The said powers are to be exercised in a restrictive manner and not in a routine manner, as it is a routine manner. Full stop. In the instant case, comma, this court is of the considered opinion that the reasons cited in the impugned order dated 14/11/2023 are cogent, plausible, and acceptable, and there is no occasion to substitute the said reasons. Full stop. Petition accordingly stands dismissed.
My lord, one my lord observation, however, I may be to the take the recourse of order 21 rule 101.
You are not required to take recourse. 101 is automatically come once you find filed 97 application. And that right is also extinguished. You have filed separate suit. Next.
54 and 55 something.
Yes,
Right, please. Yep,
yes.
I am for item number 5.
Item number
55.
55. Okay,
55, my lord, arose out of 54.
correct.
In item number 54 also, my lord, the respondent through an advocate, my lord, filed wakalatnama way back in 2022.
In this proceeding.
In this proceeding, my lord, I think the date is 31st of October 2022.
Thereafter,
Wakalatnama was filed. Later, my lord, the same advocate withdrew from the proceeding. A learned friend has appeared, but he has appeared in 55. He has not appeared in 54.
okay, we cannot force him to
Force him
appear.
to appear.
He
I'm
will-
just clearing the
He'll
record.
defend the contempt case.
Lord, I think. Well, as far as the CRPIO is concerned, my lord, that was on a very limited issue,
A 19 matter,
lordship. And my
we
lord,
will
my
take
only
it up
prayer-
for disposal if he has not appeared.
lordship can proceed against him because, my lord, obviously, my lord, the two items are connected. And my lord,
Obviously, he is in the know of the
he
proceedings.
is in the know. my
If he is in the know of the proceeding and chooses not to appear, then we cannot force him to appear.
Lord.
We'll decide it.
lordship may proceed and dispose of this matter
Okay,
because
what
on a
is the
very
matter?
limited issue, my lord. The issue was that, my lord, my prayer for the order of injunction or status quo, my lord, that was rejected by the.
You are the plaintiff.
I am the plaintiff in the land grabbing case, my lord. This is a land grabbing matter.
What
This
is the contempt for just
Contempt,
taking a digress?
What has happened is, my lord, that in the item number 54, there was an order of status quo passed by this court. That is of 4/5/2019.
Okay,
That order was, my lord, apart from the step being taken, my lord, that order was also by way of a petition placed before the learned trial court.
order of status quo.
Status quo,
Okay.
because in the trial, there was no order of stay of the proceeding as such, because we never prayed for any stay, because we want the case to proceed.
Mhm.
That order of status quo, my lord, was placed
Status quo with regard to the possession.
with regard to the, my lord, the land, yes, possession of the land. And, my lord, the order of status quo was informed by way of a petition before the learned tribunal, my lord, in which the
Now, what
the
was
respondent,
the violation?
the violation was that, my lord, during the pendency of the matter, my lord, he encroached into the land and, my lord, built a structure thereon, which we have produced the photographs.
What do you say?
My lord. Yeah, whatever construction is going on.
What is your name, Mr. Counsel?
My T Borkoti.
Mr. Borkota, yes, what is your,
My lord, whatever the construction is going on at Dock number T47, which is my own land, not in Dock number T48. In Dock number T48.
you
falls
are
under-
trying to contend that the construction is not connected with the
Exactly.
property of the suit, of the proceeding.
Exactly.
Reaction?
Regarding that, my lords, only an inquiry by the circle officer or any such officer can determine,
Yes.
because I will say that he's constructing on my land, he will say that he's constructing on his land. So that is, my lord, that is upon your lordship
Yes,
to decide. my lord.
that we can,
Lordship can ask
we can
the-
determine by a local commission or
Lord,
something,
lordship can
or by an
determine-
officer.
Lord.
Okay, and the other one, the main case,
The main case, my lord, can be. my lord,
what is your grievance?
My grievance was that, my lord, no order of status quo was passed, in spite of the fact that I have produced as many, my lord, the title deeds of the property, the.
No, you said there was a status quo which has been violated.
No, status quo, my lord, against the rejection of the status quo order, I came in civil revision petition, my lord, for this honorable.
Oh,
court.
now there is a status quo by
Yes,
this court.
by this court, my lord.
We send back since there is a status quo. No point, isn't it?
Until the
It's
disposal
almost
of
like an ad
the.
interim injunction.
Yeah.
Your ad interim prayer was not granted. This
Not
court has granted and it's been pending since 19. No point being
No,
served.
yes, my lord.
We
That
send
may
it back,
continue-
let it be decided.
Yes, and that may continue till the disposal of the land grabbing case,
Yes,
my lord. That is
okay,
all, that is
okay,
my limited prayer.
And contempt.
Contempt, my lord, lordship will.
Now,
separate it.
after initiation of this contempt proceeding,
Lord.
what is this? Did they again proceed?
My inspection is that, my lord, that structure is still there, because it is his contention that.
No, no. Were they still proceeding or is it at a halt now?
My lord, the court is proceeding, but lordship will appreciate
No,
that.
no, not the court is proceeding. The construction is proceeding.
Construction is done, my lord. In the COVID period, when, before I came, my lord, the construction was over. Because he took
So
advantage of.
we
that.
will make a thing that if the proceedings are decided in your favor, you'll have recourse under the law go for demolition?
Or lordship may dispose of the civil division, keep the contempt, my lord, because otherwise, because it will be a bone of contention. Otherwise, tomorrow he may say that my structure is there on the land since, my lord, the earlier period. That may be difficult for me.
Mr. Ganguly, you know the limitation in a contempt.
I know, my lord.
It has to be deliberate and willful. They are taking a defense that the construction is on a different plot of land. We do not have the expertise,
No.
neither the jurisdiction to go into the aspect of actual determination.
Lordship.
So it can be looked in by an officer for that. If you are saying that no further proceedings has taken place,
Good.
then we can make an observation. Provided you are successful, you can go for demolition.
My lord, in that case, my lord, the difficulty may arise tomorrow is that this structure, he may say that this is my land because, my lord, the
No, that
land are
land-
adjacent land.
No, those land that will be determined.
Well, let there be an inquiry by the circle officer and present a report by before your lordship's, my lord, because this is a contempt, my lord, a brazen violation of an order of this court. Why should the matter be remanded to this court for the tribunal for this purpose?
No, we are not remanding the contempt.
My lord,
We are saying that we
difficulty-
close the contempt, and in the land grabbing case, if it ultimately
Lordship,
you are.
for a minute, lordship will see, my lord, the conduct of the respondent. my lord,
Tell us,
throughout.
who would be tell us if his defense is that he is not connected.
Yes.
Okay, tell us, both of you suggest who will be the best
The
person to make an.
jurisdictional circle officer is the best person. Circle officer, Latmandal, my lord, they will be the best person.
Okay.
Let them determine. If there is no contempt by him, my lord,
Who will first dispose of this
Yeah.
CRP?
Yeah.
Okay.
So lordship will find the order of that I have impugned, my lord, that is at page 67.
67.
Lord. Lordship,
Yes, yes.
if I may read, my lords, from the fourth paragraph, this part, my lord, in their petition. In their petition, the petitioner, that is us, my lord.
No, we are not going to enter into the merits. Will not cause prejudice to the, let it be decided in accordance with law.
No.
This is dated 1712.
17/12/2018, my lord.
This is by the additional district judge.
Yes, my lord, acting as the my lord, land grabbing tribunal.
What is the nomenclature? Special judge
Yes, special.
or land
So this is, my lord, the special tribunal.
special tribunal. Okay. Third, Sri A. Ganguly, learned counsel for the petitioner who has filed this petition under Article 227 of the Constitution of India, putting to challenge an order dated 17/12/2018 passed by the learned additional district judge Vishwanath Chareli as passed by the learned additional district and session judge Vishwanath Chareli, acting as the special tribunal under the Land Grabbing Act
Land grab.
in J case number 2 of 2018. Full stop. Also heard three. Oh, you are not appearing.
He's not, I'm not.
None appears for the respondent in spite of notices being served. Full stop. This court has also been apprised that initially the said respondent had appeared through a counsel who had subsequently withdrawn from the case, and thereafter there was no further appearance. Full stop. Para. The Sri Ganguly, the learned counsel, has submitted that while the impugned order dated 17/12/2018, the J case was rejected and no interim protection was granted to the petitioner, who was the first party in the proceeding. Full stop. The learned counsel has also drawn the attention of this court to the order dated 4/5/2019 of this court, whereby the parties were directed to maintain status quo over the disputed land until further orders. Full stop. It is submitted that the said order was extended from time to time and is still in operation. Full stop. Para. On consideration of the matter and being apprised that there is no, Sri Ganguly has, however, submitted that in spite of the order of status quo, the second party respondent had gone ahead with the construction, and in view of the same, the connected contempt case civil 227 of 2021 has been filed and is pending. Full stop. This court has, however, seen from the records that in the defense taken by the opposite party in the contempt case, the identity of the land in question has been disputed, and it has been contended that the constructions have been done in another plot of land, and therefore the allegation of contempt has been denied. Full stop. Para. Be that as it may, this court is of the opinion that the impugned order being of the year 2018 and there being an order of status quo passed by this court in the year 2019, which is in operation till date, interest of justice would be served best if the matter is remanded back for a decision to be taken on the merits of the case. Full stop. Accordingly, the petition is closed by remanding the matter to the learned court of the additional district and session judge acting at the special tribunal. Where now? Which district?
Biswanath only.
Biswanath.
Yes. Court is still.
Biswanath. Biswanath district. Biswanath district. Have the records come? No.
No.
Full stop. The order, it is however made clear that the order of status quo passed by this court on 4/5/2019, which is continuing, would remain in force till final disposal of the proceeding instituted under the Assam Land Grabbing Prohibition Act 2010.
What the case number? Land grabbing case number 1 of 2017.
In land grabbing case number 1 of
2017.
2017. Upor to dibaje miss case number so and so connected with
Miss day number so in land grabbing.
in
case
land
number.
grabbing case number 1 of 2017. Okay. Contempt case, should we pass an order today or
Possibly passed, perhaps because the report might need some time. So 2021 might.
it might be you might get all the relief. Contempt case list this case after 2 weeks.
Good.
Contempt totally, are ready to dispose of CRP. Okay.
Habla.
56.
My lord.
Your brothers or what?
We are in a joint family.
But I find some very amusing permutation combination.
Yes, that's
Your man Friday is on the other side.
yes.
He
chooses lodge.
what is going on?
I'm the petitioner.
Are we to assume anything? Both Bagarias fighting in the court. Joint prayers. Are you making a joint prayer? It
Just
seems.
to ensure that what your lordship was saying is not there, he has kept me in between.
Okay. But that's only a will. We have to
Will.
leave the will. But only for this case. Next case, you have to go there. Yes, what is it?
My lord, at the outset,
Who are you?
I'm the beneficiary
No,
of.
you're the plaintiff. It's a suit or what?
No. There's lots of facts, also be complicated also. I'm just at the outset, before going into the aspect of the matter. What happened, Your Lordship, when we filed this Article 227 application, it is honorable court, challenging an order.
Earlier.
Yeah, this,
Oh, this, okay.
challenging an order of executing court, wherein my application for imprisonment has been rejected.
You filed an implement in the execution stage.
Execution state, because of the fact that I am the assignee of the property. Being I am in Tansbury, an assignee of the tea estate, I want to get the fruits of that execution case.
You are the assignee of the
Of the
property.
tea estate,
Of the tea estate.
by OFL relinquishment deed.
Okay.
Now, before Lordship has taken note, without wasting the time, what happened, there is a bona fide mistake that has been trapped in my application. What happened, I am thankful to my brother that Mr. Dekar, that he has brought to this knowledge by way of filing an affidavit in opposition in para 6.
Hmm.
In fact, the name of the father of the respondent number 1 and 2 and husband of respondent number 3, that is in mistakenly written as Bhavani Shankar Bagaria instead of Prahlad Bagaria. So therefore, and also there is a mistake of an address, though they appeared, and the numbering of suit. So that is in the.
Is it going to make a material defect or a problem? No.
Because they are also agreed. Yeah. That I'm just pointing out.
That if it is not affecting the adjudication process, we'll correct it. No problem.
Yes, sir. So therefore, Your Lordship, what happened that in the year 1987,
Yes.
on 31st 1987, a deed of relinquishment has been executed
Yes.
by the predecessor in interest of the respondent
Yes.
in favor of the predecessor in interest of the petitioner. That is my father. In that deed, my lord, the predecessor in interest of the respondent has executed the deed as a karta of an HUF property, the joint Hindu family.
Well, please come again. What has happened?
That deed was executed
Yes, by the
by the
predecessor in interest of
transferor
the-
as an incapacity of a karta
Okay.
of a
The
HUF.
you are contending that the predecessor in interest of the respondent was the Karta of the family, Hindu HUF.
HUF.
Okay.
Now, what is the dispute? The dispute was that I was brought in the family of this Bhavani Shankar Bagaria, who was the karta of the family. He was the adoptive son of Girdharilal Bagaria, Sardarmal Bagaria, and Narayani Devi Bagaria.
Adopted son of?
Sardarmal Bagaria and Narayani Devi Bagaria.
He was the adopted son. Okay.
Yes. Similarly, the predecessor interest of the petitioner, Nankishore Bagaria, also living with this Sardarmal Bagaria and Narayani Devi.
What is the name of your father?
Nankishore Bagaria.
Nankishore. Nankishore.
Yes. All are family members too.
Okay. Then what happened?
Then, Your Lordship, Narayani Devi Bagaria,
Bagaria.
Narayani Devi Bagaria, there is the wife of Sadarmal Bagaria, she had executed an will in favor of non-Kishore
Okay.
after the death of Sadarmal Bagaria. And thereby bequeathed some immovable property.
Okay.
Thereafter, on a mutual understanding, some of the properties of the joint family, that all those family were given to the father of the non-Fisher by way of this deed of relinquishment.
There are two deeds, two instruments. One is the will, one is the relinquishment
Yes.
deed.
So thereby in the relinquishment deed, I waive my right, non-Fisher waived his right in respect of that will and said that I will not claim any benefit of that will. That is our stand. And upon such settlement,
No, no, relinquishment deed was not by your father. It was by the father of the respondents.
yes, in
So,
favor of the father of
In favor of
the
non-Kishore.
Yes,
In favor of non-Kishore.
non-Kishore.
So there is no question of you relinquishing anything.
No, I am saying in the deed, in the body of the deed, I say that I will not claim any, because the will was the prime object of the disputes. That
No, when the relinquishment is by the other side, where is your scope of saying that I?
no, I'm not. There is this recital in the part. I'm just saying in
Okay.
respect of the dispute, my lord.
Okay, okay.
There is the recital of the
That you will not be seeking any
claim
on the will.
on the will. So that is in the
You will
recital.
be the beneficiary of the relinquishment. So in lieu thereof,
Yeah.
you will forego your rights under
Yes,
the
yes,
will.
absolutely,
Okay.
absolutely correct.
But this
And that is not the dispute.
relinquishment is by Bhavani Shankar Bagaria.
Ah.
Correct?
Correct.
Bhavani Shankar Bagaria, you said that he passed away, and thereafter Narayani Devi Bagaria had
No,
prepared.
Sadarmal Bagaria.
Oh, Sadarmal.
Sadarmal Bagaria is the original owner.
Okay, okay, okay.
He was
understood,
the
understood.
Karta earlier.
Okay. On his death, Narayani Devi had prepared a will, and thereafter his son said that I'll have a
Yes,
replacement
yes.
deed. You forego your
Yes,
right under the will.
that's fine.
Okay. Mm.
And that is not the dispute at all in the present application.
Oh, yes.
Now, since 1987,
Mm.
with effective date from 1/4/1987,
Mm.
our predecessor got all the right, interest, liabilities, everything
Mm.
of Mathula tea estate.
Nathula.
Mathula,
Mathula.
M.A.
Thula.
Mathula, yes.
M.A.
P-H-A-O.
Mathala.
P-H-O-L-A.
M.A.
T-H-O-L-A.
Mathola.
Mathola.
Where is it? Tinsukia.
It is Dibrugarh.
Dibrugarh. Then what happened?
Then everything is going well, everything has been settled.
Mm.
Now, during the course after that, we got to know that one suit was filed by Bhavani Shankar before the court at Dibrugarh
Mm.
for a specific performance of a contract.
Mm.
There was two agreements, my lord, both of 1970, with the then Jokai India Limited, Jokai, in respect of Bockel, part of the Bockel tea estate and part of the Decom tea estate. Two agreements were, separate agreements were executed by the owner of Bockel and Decom.
Bokelan.
Decom,
Decom.
D-I-K-O-M,
Tea estate.
Tea estate.
With Bhavani Shankar.
with Bhavani Shankar.
Mm.
Now, in that agreement, in both the agreement, Bhavani Shankar was represented as a proprietor of Mathula.
Hmm.
There is no dispute.
And Mathula, you said that it came to you
Yes,
after, as part of the relinquishment.
relinquishment. Now, my case is very simple.
And these agreements were of which year?
In 1970,
70. Both the
1970, and then after 7 years in 1977, he had filed a suit. And that suit finally,
But
Agreed.
77 is before the coming into operation of the execution date. You said 1/4/1987.
yes,
The agreements were of 1970.
1970,
77 suits filed
77 suit filed.
for specific performance.
Yes, it was decreed,
Okay.
went to High Court, went to Supreme Court. Then finally
Suit
decreed.
was for
Suit were for
specific performance.
specific purpose of both the agreement.
Okay. Decreed.
Yes.
In favor-
Meanwhile, one
Suit
another
decreed in favor of Bhavani.
Bhavan,
Decreed and confirmed by Supreme Court.
till went to the Supreme Court, and
Confirmed.
finally it was, and finally the execution case was filed.
Execution case filed.
Now, meanwhile, another facts I would like to
Okay.
draw the
And
attention.
in the execution, you want to implead yourself.
Yeah.
You said that you
And
should be-
my saying is that since you executed the deed in being a proprietor of Mathula, and the Mathula comes to me, so all the fruits coming out from that agreement and subsequent proceeding.
Wasn't it list pendants? It is a subject matter of a pending suit.
That is it. Therefore, we are before the executing court saying that the assignment of my right by way of the deed, and therefore the fruits of that execution case that has to be come to my share.
Was there any reflection in the relinquishment? deed?
No, that is
Because-
that was concealed in the, because I am unaware of that fact, and in relinquishment deed there was no representation by the Karta that two agreements were executed and that suit were filed, etc., etc.
What is the date of the relinquishment deed?
Relinquishment deed
Oh,
is
31/3 to 1987.
31/3/1987.
That means almost a decade had passed since institution of the suit.
17 years, 17 years,
No, 77 or 87.
10 years.
10 years.
10
A decade had passed.
Yes.
But there was no reflection in the relinquishment deed.
Relinquishment deed.
Okay.
Now, we filed two applications before the executing court.
But relinquishment was by the father of the present respondent.
Yes, in the capacity of a Karta.
Okay.
And it is not in dispute.
Now, what is your?
They also agreed that deed was the original agreement was executed, not only HUF, Karta is a HUF, also the proprietor. And the earnest money of that agreement of 1970, that was from the HUF fund. There is no dispute between the parties.
There is a dispute. Here, there.
The fund was given by the HUF, there is no dispute, because the receipt has been issued. Now, I am not, because the Lordship is also appreciate my submission, we cannot go into all these factual metrics, all disputed facts. Because it is not a
Now-
forum, my lord.
Now, what is the grievance? What is the impugned order?
Yes, that is the learned executing court stays upon the grammatical interpretation of the cause title of the agreement. But you will find the relevant part is page 58. I have two applications I have filed, my lord. One is for implement, and another is under section 47, read with order 21, rule 101.
But how do you invoke 2210? 2210 will be during the pendency of a suit.
Yeah.
If the suit has,
There's two. Basically, I am not going into all technicalities. we filed an application under Order 1, Rule 10 for implement. Now, in execution proceeding, I'm a stranger, so I must be entered into your law. I should not be remedialist. Even if there is no provision in my law,
You can't file the suit.
I'm not filing a suit because
Can't you file a suit?
no, I'm not filing a suit to claiming the fruits of that because there is no. The only question is to determine that whether I am entitled
So
or not.
where is the bar in filing a suit? Raising all your points. The execution court is a very, it exercises very limited powers. It is interested in how do you execute the decree.
No, I'm
And,
not.
yes, of course, Order 21, everything will be there. Third party may enter, third party may say that no, he's being affected. There is not a case that you are affected. You want the fruits of the decree.
Lord.
You said that you have the right on the strength of a relinquishment deed,
Lord.
which was executed after
Relinquishment.
no,
87.
87, it was the deed of relinquishment. And in spite of in the relinquishment deed, but the worst part is that in the relinquishment deed, there is no mention about this.
They mentioned about. Now there is there was a
No,
concealment.
we are not saying that you don't have a right because by the relinquishment, as you have narrated, we have not heard Mr. Mazumdar, but you have sacrificed or whatever you have done away, foregone your rights under the will.
Yes.
So it's a quid pro quo. Will you live? You get the relinquishment part.
Yes. No,
Mr. Mazumdar?
no, I'm just finishing.
No, we are not finishing this matter now.
Okay.
We're just having his
Lordship.
response.
Your lordship has rightly indicated he has to file a suit because he is trying to say final order 22 rule 10 presupposes either
Pendency
relinquishment,
of pendency of
assignment during
yes.
the pendency. And
No, we are not even on the question of assignment or relinquishment.
lord.
The entire procedure laid down in 2210
Yes,
is the basic condition the suit has to be pending.
exactly, ma'am.
Suit is not pending.
Okay. The language itself is very clear, my lord.
Very clear.
Language itself is very caption, my lord. The
Now,
heading,
if we remember correctly, it's a very
yes, it
No,
says
no, that's
procedure,
correct, Lord.
procedure in case of assignment before final order in suit. In other cases of assignment, creation or devolution of any interest during the pendency of the
during
suit.
pendency.
It is not his case that during the pendency of the suit, something has happened by virtue of which I have become or there has been an assignment or creation of any right in my favor.
And you
And
cannot
then,
even
my lord,
and you cannot even contemplate that I'm going to file an appeal.
exactly.
All appeals filed.
Yes, everything is over.
Finished.
My lord has put a very pertinent question here. Can you not file a suit? Because he has to file a suit because
To
first
file
of
a
all, since there is directly, he is also not saying that there is any assignment or creation. What he is trying to say, my lord, on the basis of a language used in the subsequent relinquishment deed of 1987, he is trying to say that some right has been created in my favor in the agreement of 1970. So all these things, my lord,
And Mr. Dutta, even if we just for the sake, we accept whatever you were saying, but can the execution go to those extent of what the relinquishment deed was? This is
That
not
is-
Lordship,
this is
that-
not an application under 2197 where
Yes.
101 may
that
come
is
in.
why I
That-
say,
that
my lord,
also I
lordship has put a
filed.
very
Where?
pertinent question, because
That's what they
unless-
filed.
my lord,
That is
unless-
that is not the order passed in this.
No, I'm therefore, before my senior friend has submitted, Your Honor, I would like to just clarify. We have filed two applications because I'm a stranger, so I have to enter into.
Yes.
That is one application. Whatever is order 22, order 1, or section 151. The second application also I filed under section 47, also 21, order 21. For adjudication and paying all reliefs. I have annexed.
21, 97, 99 you have invoked.
Yes, but
is this is this order passed where? In which?
no. What happened, Your Lordship? But the first application rejected, and then the executing get fixed for the hearing for the next application.
Where is
How-
the rejection of that order? Which order?
The impugned order, page 58, the operative.
No, this is 110.
One day. Now, Lordship kindly.
We are adjudicating the rejection of 110.
Here. Now, Lordship kindly comes to page 61.
61. Internal page.
61,
Into 61, it's a part of the impugned order.
yes.
Is internal paragraph?
Now, last line. Now come to
Paragraph.
no, no. This is the impugn order in the our application.
Now, what is the paragraph number?
This is paragraph number 9.
9.
9 is 11 last.
11 last. Okay. Yes, please read.
Now come up now to come up on to 26/5/2000 for hearing on petition bearing number 423/2018.
No, now to come up, yes.
So this application is Lordship will find at page 62.
That 426 is still there.
Yeah. So therefore, our simple contention is that the Lordship already in another matter before us, Lordship has also go through and saying the suit is when an application has been filed under 21, then I cannot file a suit.
No, if your application under order 2197 is pending and is fixed for hearing on 26/5/2023, which is already over, what will happen on 26/5?
No, therefore, before that we come, because unless I entered into in the execution proceeding.
That's not required.
So then Lordship may clarify and we'll go to
the. What is the requirement of filing order 1 rule 10 in an execution?
The
proceeding
Lordship
by third party?
may clarify.
97
No, not required. In fact, that is meant for a third party stranger.
So then Lordship will
We'll
say we
clarify.
should close them and we will go for here.
Yes.
Yeah.
Third. Sri B. Doctor, Learned Counsel, Learned Senior Counsel for the petitioner, assisted by Mr. Bonik or who is assisting you?
No. Bonik.
Or Mr. Deka. Let the dispute begin.
We'll have a cup of tea, Lordship,
outside
and
the
finish up
court.
the disputes.
Not between you.
Not
between you.
hosted by my senior colleague.
Not between the council, between the parties.
Only prayer, you Lordship, and we will close up. I am not interfere. But that the execution proceeding is still pending. So if the money goes, your Lordship, then entire exercise will be futile. That
I
cannot.
don't think
Petition such order can be filed.
when the learned court has fixed 26/5/2023, and probably because of pendency of this case, no proceeding.
No, nothing happened.
I don't think.
Nothing happened.
Okay. Assisted by Sri S. কোনে লিখিব তুমি লিখিবা নেকি নাকি না লিখিলে নাকি তোমাৰ এটা আছে নেকি আগৰ আগতে Please have your seat.
Yeah. We prepared a note, your Lordship, for the facts, not.
Heard. Sri B. Doctor B. Learned Senior Counsel for the petitioner, assisted by Sri S. Bonik. Also heard Sri D. Madhumdar, Learned Senior Counsel, assisted by Sri S. Deka for the all the respondents.
Yes.
Are you sure?
Yeah.
For all the respondents. Full stop. Considering the facts and circumstances, and as agreed to by the learned counsel for the parties, the instant petition is taken up for disposal at the admission stage itself. Full stop. Para. The application has been filed under Article 227 of the Constitution of India, challenging an order dated
10/9.
is a case of which year?
54. Sir.
No, case of 19.
No.
There is a mistake in the certificate.
No, in case of which year? This one? 23. Why have you filed so late?
No, immediately filed.
Was there a delay condemnation or what?
No.
Certified.
What is the date?
Certified copy, there is a mistake in the
part of the.
The date of the order.
date of the order is 10.
10? 10/4?
26/5/2020.
Yes.
The certified copy, the portfolio has wrong
It's not 19.
Not 9.
It cannot be 19. We are,
Yes,
26/5/2020.
it cannot be 26/5. 26/5 was the next date. 26/5 is the next date.
no, 26, 5.
What was the date of the order?
19 হবে না।
I think 10/4/2023.
Yes.
10/4/2023, most likely.
Yes, because immediately we come.
Because they applied for certified copy on 12/4.
Yeah, 12/4/23 we will got it. 23.
কি করলো? Order dated
Because next date also given.
10/4/2023 within bracket wrongly typed as 10/4/2019 in the certified copy bracket where it goes by the aforesaid
Oh, 19.
order, comma, the petition bearing number 255 of 2018 filed in title execution case number 2 of 2014 under order 1 rule 10(2) read with section 151 of the CPC has been rejected. Full stop. Para. Though considering the order proposed to be passed, comma, a detailed narration of the facts may not be necessary, comma, it would be convenient to if certain basic facts are put on record, are not so put on, are narrated in this order, full stop. The suit is of the year
1970.
suit is of the year 1977.
And 98.
Two suits
Yes.
or renumbered.
Two suits. Two agreement.
Two agreement, two suits.
The suits, the two suits were instituted in the year 1977 and 1983 for specific performance of two agreements. Full stop. The petitioner herein contends to be the successor in interest of one Nand Kishore Bagaria, who was the beneficiary of a deed of relinquishment dated 31/3/1987. Full stop. It is contended that though the father of the petitioner was also to be the beneficiary of an will, comma, in view of the aforesaid deed of relinquishment, comma, the benefits were restricted to those contained in the said deed. Full stop. It transpires that the suits for specific performance of contract were instituted against two tea estates prior to the execution of the relinquishment deed. Full stop. However, there was no mention of the pending suits in the said deed. Full stop. Para, be that as it may, comma, the suit having been decreed and being upheld by all the appellate courts, including the Honorable Supreme Court, comma, the same has been
During the pendency of, before the Supreme Court, the matter was compromised.
Decree was,
Yes.
it was,
No,
the
we-
decree was put to execution. Full stop. Since the petitioner was not parties to the said suit and having come to know about the execution of the decree and staking a claim that he should have the fruits, he is the actual beneficiary for the fruits of such decree, had filed two applications. One under Order 1, Rule 10, within bracket 2, read it 151 CPC, which is the subject matter of the present petition, and the other under Order 21, Rule 97.
Yes. 147. The section.
Rule 10.
Rule 10.
Rule 101.
101.
Yes.
Under section 47, read with Order 21, Rule 101
Right.
of the CPC. Full stop. Para. Three. Para nahi. By the impugned order, as narrated, as observed above, while the application filed under Order 1, Rule 10(2), read with Section 151 of the CPC, has been rejected. Full stop. Para. The learned senior counsel for the petitioner has submitted that by the aforesaid rejection, the petitioner is likely to be caused immense prejudice, as he would not be in a position to put forward his claims at the time of execution. Full stop. It is submitted that the reasons cited in the impugned order are not relevant and is against the established principles of law, wherein a broad outlook is necessary in adjudicating a petition under the aforesaid provision of law, whereby all necessary parties are to be given a fair opportunity of hearing. Full stop. Para. Per contra, Sri Mazumdar, the learned senior counsel for the respondents, has submitted that the rights of the petitioner, if any, has not been extinguished by the impugned order, inasmuch as the other application filed under Section 47, read with Order 21, Rule 101, is still pending. Full stop. He submits that the petitioner will have all the avenues and scope to stake his claim.
These 30-minute record. I'm only saying that this Order 22 rule and regulations are
Still
maintained.
pending.
This may affect
The
me-
London Senior
affect
Council
me.
accordingly submits that the question of suffering any prejudice would not arise. Full stop. Para.
This is not maintained with that.
Full stop. He has also submitted that the present petition under article, by justifying the impugned order dated 10/4/2023, the learned senior counsel for the respondent has submitted that the petition under Order 1, Rule 10(2) was not even maintainable. Para. The rival submissions have been duly considered. Full stop. A careful perusal of the impugned order dated 10/4/2023 would reflect that while the petition bearing number 255 of 2018, filed under Order 1, Rule 10-2, read with Section 151 CPC, was rejected, comma, the other application being petition number 426 of 2018, filed under Section 47, read with Order 21, Rule 101, was put up for consideration on the next day, fixed, that is 26/5/2023, full stop. This court has been apprised that due to pendency of the present case, comma, the further proceedings were not carried forward, full stop. Para. A perusal of the provisions of Order 21, Rule 101 would make it clear that all questions raised in an application filed by a party, filed by a litigant who was not a party in the suit or proceeding, would be determined by the executing court by deeming the same to be a suit, and such questions may not be raised by a separate suit, full stop. For ready reference, comma, the aforesaid provision of law is extracted herein below, Order 21, Rule 101, full stop. This court is of the considered opinion that rejection, that without even going to the aspect of maintainability of an application under Order 1, Rule 10 CPC at the time of execution, comma, this court is of the considered opinion that rejection of the aforesaid application would not cause any material prejudice to the present petitioner, inasmuch as their application under Section 47, read with Order 21, Rule 101, is still pending, and as provided in the statute itself, comma, such questions would be determined by the said court, and all such questions would be determined by the said court and not by a separate suit, full stop. In this court has also been apprised, comma, as observed above, that the suit has not proceeded, that the application has not proceeded because of the pendency of this case, full stop. Para. In view of the aforesaid.
Just in the impugn order, there is some observation on marriage, which would affect that maybe clarified.
Okay. Last what key Last line. Last line. In view of the aforesaid facts and circumstances, comma, the present petition is closed by directing and by remanding the matter. Closed with an observation that the pending petition under Section 47, Rule read with Order 21, Rule 101 of the CPC, be decided on its own merits and without being influenced by the previous order passed in the application under Order 1, Rule 10,
As well as by your.
as well as
by
any
the court.
observations made by this court
Yes.
in the present order. Full
No.
stop. Para. Since the parties are represented before this court, comma, let the next date. Are dates fixed?
No, Lordship.
It
We
is
would
kept
be
on hold.
directed to appear on.
Let the next day, let the parties appear before the learned court of the additional district judge, FTC Dibrugarh, on, yes,
1 month.
please, have a date
In the month of June 24th.
on 24th of June.
Along
2020,
with a copy of this order.
2024, along with a copy of this order,
Yeah.
whereafter the learned
Court
court
will
will proceed
in
in accordance with law.
Got
Grateful. Lord. Much ado about? About? Nothing.
Nothing.
Yes. Oh, I will come. Oh. We'll take a break of 5 minutes. Mr. Kolita, what is this?
The decision taken appeal against the dismissal of the appeal.
Concurrent,
No.
reversal.
What happened, the original suit was decreed against the appellant. Present
You're
appellant?
the defendant.
Yes. Then
Appellant,
appeal
appellant
was filed.
is the defendant.
Appeal was filed.
Suit was for?
Suit
Suit
was for declaration of right appellant interest.
Declaration, right, title, interest. Okay. Suit was decreed.
Suit was decreed, my lord.
Thereafter,
Then, my lord, the
you preferred an appeal.
appeal filed, but the appeal was delayed, my lord. There was delay of 286 days.
Or your
So-
first appeal.
Yes. Then an application for condonation of delay was filed,
Delayed by 200?
86 days.
Okay.
Then
You filed section 5 application.
Yes, madam. And a miscase was registered, my lord. The learned appellate court, my lord, disposed of the miscase, dismissing the
Application.
petition. Thereafter, my lord, another order was passed that as the miscase was dismissed and delay was not condoned.
Correct.
So, my lord,
Suit, appeal was dismissed.
against that, my lord, we have come before your lordship.
Okay.
Then here, my lord, your lordship may be pleased to see the condonation of delay application.
Okay.
I have filed.
You're only on the part of the delay, dismissal of the condonation application.
Condonation application, my lord, along with the, because the appeal was also dismissed. my lord.
Correct, correct.
So second appeal, my lord.
No, that is okay. That procedure is okay. This has been clarified 2005 Supreme Court, no revision, it's an
Yes,
appeal.
Yes, my lord.
Mr. Mohanta will remand this back.
Lord, I would not have any difficulty to concede it.
280 days,
Had
286
there been
days.
some explanation. That is the predicament. Difficulty is probably the learned court below would have also considered for, but unfortunately there is no explanation particularly for the relevant period. How to invoke section 5?
Yes,
There lies the difficulty, my lord.
your lordship,
Otherwise, I also thought it initially.
your lordship will
But,
consider
there
my
is
application because
nothing
I have
to-
filed this. Here, my lord. And my lord, the
No, this application, this appeal, pleadings made in this appeal will not help you. We'll go
Yes.
by the pleadings made in the section 5
Section
application.
5.
But let us remand this back.
Well,
The second appeal on these questions, we are not.
well, true, but then what I find also,
We'll record your vehement objections and including to impose costs. Yes, we are going to impose some costs.
yes, my lord. Because
Idea has come.
virtually and practically there is nothing. Explanation, there is nothing I have gone through. I have read the judgment order. of the learned
Let us see
court.
the order.
I'll see the order. There is nothing, no explanation. I have
Page.
gone through there.
Page.
At the page, it starts at page 6.
6.
Yes.
learned appellate court, my lord, considered their judgment, but what I have filed, not a single
Not
touch.
necessarily, my lord. Had there been some explanation.
Let us see your
Yes, my lord, let us see.
application. Mr. Kolita, your application.
Application is at my lord, page
13.
13, my lord.
1-3.
Starts at 13, yes.
13. Your lordship can go through from page 17, my lord. I have given the explanation properly.
Until April
Interesting
7.
case, my lord, the original record was called for. After return, my lord, no information was given to the advocate that the appeal was returned
Let us see your,
in the trial court, my lord.
let us see what have you stated.
At page 17, para 6, my lord. That the appellant states that in connection with another case, the learned civil judge Kamrup called for the record of the present suit. That is the original suit, my lord. Accordingly, the learned munsif number by order. that is
You are
so and
reading
so,
paragraph 7, page 17.
Page 17.
Paragraph?
That is the condonation of delay
Yes,
application.
yes, paragraph?
Paragraph 6, my lord.
Paragraph 6. Okay, okay.
Yes, my lord.
That in the, okay.
The
Yes.
appellant states that in connection with another case, the learned civil judge number 1 called for the record of the original suit, title suit, my lord. Present suit. Accordingly, the learned munsif by order dated so and so was pleased to send the record to the of title suit number so and so to the court of civil judge number 1 Kamrup. During the period, the appellant was suffering seriously from his illness and he had to go outside the state. Then, my lord, next
So
paragraph.
what illness were you suffering? What serious ailment? Mental depression? BP?
Illness.
What illness? Sugar?
No, my lord.
BP?
But I have given all the certificates, my lord.
What illness?
Heart plus other things. Ailment of the heart also. Because he is
Is that an ailment?
aged person. my lord.
Heart ailment. Everyone has a heart ailment.
Actually, he went to AIMS, my lord, thereafter Delhi, Apollo, then Hyderabad, again came back. And at that time, my lord, the Mr. Solen Mehdi was the advocate, my lord. In the meantime, he also expired. So he did not know anything about the suit. Details of the suit, my lord. And this record was called for. After return, my lord, trial court did not give any intimation that the record has come back.
The records were not there.
Originally, my lord, suit was pending before the munsif. Record was called for by the civil judge number 1. Then record returned, my lord, without any intimation to the advocate for the defendant.
No, records in the trial court. Trial court.
Suit was pending, my lord. In the suit, my lord.
No, was it an ex parte decree?
No, not ex parte, my lord.
Then if it was not an ex parte
Later
decree,
on ex parte, my lord. After that, it is ex parte.
It did appear.
Earlier to that, my lord.
in the final stage you did not appear.
Yes, my lord.
Oh, you did not
No,
contest in the
no
final stage.
information, my lord. No information.
Okay.
Advocates, actually, it was the duty, it ought to have been duty of the learned court, trial court to show the record, that the record has come back from the civil judge or Eastern District Judge number 1. That was not done.
Oh, in the final stages of the suit, you did not contest. Could not contest. You are not
Yes,
having knowledge.
no.
Okay.
That was the main, yeah.
And paragraph 7, you have given the details
That-
of your
That I have
medical
explained, my lord.
treatment.
That after it depends that the order so that the learned munsif received back the case record
okay.
from the court of the civil judge number 1.
Okay.
Then, my lord, treatment I have explained. In the middle of para 18,
We
my
have
lord,
seen.
I have stated.
We have seen.
It was all prior to the
Yes.
prior to the date of the report. These explanations are
Actually-
all prior to the final order of the court.
Illness was continuous.
Say that the requirement is after. You explain the period after we have passed the order. There was nothing.
Illness was
There was
continuous.
not
When did you come to know about the decree of the court?
Yes, my lord, that I have explained. Yes,
they-
at page 18, my lord.
19, paragraph 9, kindly.
Page 18, last, my lord. That after some improvement of his ailment, the appellant came back to Guwahati in the last part of
When was the suit decreed?
decreed 17/5/2017.
17/5/2017. And your ailment was when?
Earlier to that, my lord.
When was the records transferred to another court?
That is at page, my lord. On 29/116, my lord.
Okay. The instant appeal.
And
Then, my
thereby
lord,
Lordship will
in
find,
para 9, my lord, I have
para
explained.
9 here says, after knowledge about the passing of the decree, the petitioner applied for the certified copy of the judgment dated on 1/2/2018.
Okay.
But when was the knowledge? When he derived the knowledge, nothing happened.
No,
There is no, not to speak of
above
details.
I have stated in page
Okay,
19, my lord, above.
okay, well, let us pass the order. No. The instant appeal has been preferred under section 100 of the Code of Civil Procedure against an order dated 4/11/2022, whereby the learned civil judge number 2 Kamrup M had rejected had rejected mid-J case number 187 of 2018, which was filed under section 5 of the Limitation Act for condonation of delay. Full stop. Para. The facts in brief which transpire from the materials on record is that the present appellant was the defendant in a suit instituted for declaration of right, title and interest, which was registered as TS number 437 of 2007. Full stop. It is contended that during the pendency of the suit, the records thereof were transferred to another court in connection with TS number in another court. Full stop. Full stop. It is though the appellant as defendant had initially contested the suit, subsequently the appellant was not aware of the return of the records. Full stop. The appellant has also cited that due to medical reasons, the appellant had to undergo treatment outside the state, including the All India Institute of Medical Science, New Delhi, and other places. Full stop. The appellant was not aware of the disposal of the suit on 17/5/2017, and on coming to know about the same, had preferred title appeal 17 of 2018 along with an application filed under section 5 of the Limitation Act, which was registered as Ms. J 187 of 2018. Full stop. The learned court, vide the impugned order dated 4/11/2022, had rejected the said Ms. J case, and consequently the title appeal was also rejected, was also dismissed. Full stop. Para. I have heard Sri P.K. Kolita, learned senior counsel for the petitioner, assisted by Sri K.R. Barua, learned counsel. Full stop. I have also heard Sri K.K. Mohanta, learned senior counsel, assisted by Ms. Ann Begum, for the respondent number 1. Full stop. Para. The senior counsel for the appellant has submitted that the approach of the learned court below in adjudicating an application under section 5 of the Limitation Act is not in accordance with the settled principles of law. Full stop. It is submitted. Please have your seat. It is submitted that though proper reasons were cited, the court, the learned court, took a hyper-technical approach whereby the substantive right of the petition of the appellant has been defeated. Full stop. He further submits that the appellant, by the impugned order, is sought to be deprived of an effective opportunity to defend his case in the appellate stage, which is a right created by the statute. Full stop. Para. Per contra, comma, Sri Mahanta, the learned senior counsel for the respondent number 1, has submitted that Section 5 of the Limitation Act has to be construed in terms of the reasons assigned in such an application and not in a mechanical manner. Full stop. By referring to the impugned order dated 4/11/2022, comma, the learned senior counsel for the respondent has submitted that the learned civil judge had considered all the aspects sought to be projected by the applicant in the application under Section 5 of the Limitation Act, and after assigning cogent and acceptable reasons has dismissed the said application. Full stop. It is submitted that though a lenient approach may be taken by the court, comma, such leniency should not extend to give undue advantage to a party which is not diligent to pursue his remedies. Full stop. It is further submitted that the rights accrued to his client is a substantive right upon pronouncement of the decree, and such right cannot be taken away in a mechanical manner. Full stop. Para. The rival submissions advanced have been duly considered. Full stop. Para. The question which would arise for determination in the second appeal is as to whether the approach of the learned civil judge number 2, Kamrup M, in dismissing the application filed under Section 5 of the Limitation Act was correct, and whether the reasons assigned for such condonation were properly appreciated by the learned court. Full stop. Para. A perusal of the impugned order dated 4/11/2022 would show that the reasons cited in the applications were indeed taken into consideration. Full stop. The order reflects that the ailment of the petitioner, of the ailment of the appellant, and his treatment in the AIIMS or Apollo Hospital in New Delhi were also taken into consideration. Full stop. However, comma, the learned court had also noted that no proper medical documents were annexed in support of such reasons. Full stop. Para. Prima facie, comma, the order passed by the learned court below cannot be faulted with, as reasons have been assigned. Full stop. Para. Having said that, comma, this court is, however, is also required to look into the manner of an adjudication of an application for condonation of delay. Full stop. Para, it is a settled position of law that a pragmatic and justice-oriented approach is required in adjudication of such an application. Full stop. In a recent case, the Honorable Supreme Court has, after considering the earlier judgments on the aspect, has laid down certain parameters which are to be taken into consideration while deciding an application for condonation of delay. Full stop. Para, in the landmark case of Katiji, reported in so and so, it has also been laid down that every day's delay is that the learned court adjudicating such an application is not to insist upon every day's delays, insist upon an explanation on every day's delay. Full stop. Para, in view of the aforesaid facts and circumstances, just take a minute. This court has also considered that the Honorable Supreme Court, in the case of Shyam Sundar, 2005, so and so, whereby it has been clarified that dismissal of an application under Section 5 accompanying an appeal would also mean the dismissal of the appeal, and therefore there is no dispute in the bar regarding the maintainability of the present second appeal. Full stop. Para, considering the aforesaid facts and circumstances, the court is of the opinion that interest of justice would demand that the substantial question of law as recorded above be answered by answered in favor of the appellant by observing that the explanation, by observing that the application for condonation of delay is to be allowed. Full stop. The aforesaid direction is, however, subject to payment of cost of rupees, suit of which year? Of rupees 5,000. Full stop. The matter accordingly is remanded back to the learned Civil Judge number 2, Kamrup M. Guwahati, for adjudication of the title appeal 17 of 2018 in its according to law and in its own merits.
There are
What is the IA for?
There are two missed cases, my lord. One is stay and another is for injunction, my lord. Here, my lord, we have filed. Because, my lord, they are in some portion of
You pray for injunction there?
Yeah.
Not here.
actually, my lord.
No, since we are, see, unless the courts assume jurisdiction after condonation, the court will not be in a position to pass an injunction. Now the limitation has been taken care of. You pass
A date of appearance will be given, my lord.
Since the contesting parties are before this court, they are directed to appear before the learned court of the Civil Judge number 2, Kamrup M. On, yes. Mr. Mohanta?
Sometime in July.
No, will appear before on 24th, 25th of June.
25th of June for appearance.
Appearance.
For further orders.
25th of June, full stop. The appellants are also at liberty to, you had filed injunction, I think, there.
Not as a
Actually,
lordship
my
would
lord,
not have to say anything.
What
No,
happened,
I think you have already filed
what happened, my lord,
injunction.
in the plain, my
Yeah,
lord,
it is there.
in the plain, my lord, they stated that we are in some portion of the possession and they are also in some portion.
No, we are not saying anything. We're not saying. See, it's not a question of stay also. You are saying injunction.
Yes.
Injunction is your discretion, you can file.
Yes, we will file, my lord, but
On which date, from which date the learned court will take charge of the proceedings.
actually, in the meantime, my lord, there is a police case, my lord. That's why, my lord, I have prayed that the status quo may be obtained till the.
No,
appear.
there I have serious one.
No, was there any injunction or stay order passed by the
They
court?
are threatening to.
No, no, here, this court is, matter is pending since 2023. Was any interim order passed?
Nothing.
Well, this we have to. I discussed.
My lord, what is your lordship passed, my lord, that was supported by the Honorable Supreme Court in 22 itself. When the application for condonation of delay is pending, my lord, appeal must be heard. That was the.
They are all subjective, my lord. It's not all on the basis of.
No, it is same facts, my lord, same facts.
Okay, okay. Good. Oh, that is. Oh. Yes, and then I see. Mr. Jha and Mr. Talukdar, we are modifying the last part. Will not allow you to go for summoning the witness. It's your witness. It will not open a floodgate. You make them appear. If you fail to appear, we're giving you an opportunity. Otherwise, again, it will be unending.
Regarding DW5, I can proceed.
See, these are your witnesses. These are not summoned witnesses. Now we are not allowing the summons to be. We have rethought about this matter. We give you a chance to make them appear on 19/6/2024.
DW3 or lordship?
DW3, DW5, both. We are modifying that order. Yes. It will be, you'll get the certified copy to 19/6 we have fixed. Date we have not changed. Yes.
My suit, Your Lordship. I was the defendant in the suit, Your Lordship, and the suit was decreed, and thereafter I preferred the appeal, and the appeal was dismissed. The brief facts is that, Your Lordship, that
It's come up for admission or what?
admission.
Okay.
The plaintiff's case is that
দেখা এখন তাতে থৈ দিল আগৰ এইমাত্ৰ কেছটো যে হৈ গ'ল appellant is what? Defendant.
appellant is the defendant.
How many appellants?
Single appellant. Appellants, there are 7 appellants, Your Lordship.
7. Suit for?
Suit for declaration of right title interest and eviction.
Eviction. Suit decreed.
Suit was decreed.
When? By which court?
Suit was decreed by the Civil Judge Junior Division, Tirang, on 22/4/2019.
22/4/2019.
19.
Okay. It filed an appeal, preferred an appeal.
Appeal was preferred.
Appeal before?
Appeal before the Civil Judge Senior Division.
TA, title appeal.
Title appeal.
What was the suit number?
Suit number was TS 9/2018.
18. Title appeal?
Title appeal 2/23.
Dismissed.
Appeal was dismissed.
When?
Appeal was dismissed on 14/8/2023.
14/8/23. Yes, appeal dismissed.
The plaintiff's suit is that plaintiff's father, Khanindra Varman, was the
What
owner.
are your substantial questions?
Lordship, I have reframed certain substantial questions. In a nutshell, Your Lordship, the plaintiff and the defendant number 1 are brothers and
Just a
sisters.
minute, Mr. Mukherjee, just a minute. Solely under Jamabandi. Yes, what had happened?
First with the plaintiff and the defendant number one are brothers and sisters. Your Lordship. The father of the plaintiff and the defendant
Plaintiff and defendant number one are brothers.
brothers and sisters. Phanindra Burman was
How
the
many
father.
plaintiffs are there?
There was one plaintiff.
Hmm. And defendant are siblings. Defendant number one only.
Defendant number one.
Siblings.
Defendant number 2, 3, and 4 are the sons and daughters of the defendant.
Defendant number
The other defendants are the sons and daughters of the defendant number one.
one. Okay. The other defendants. That means the 6 defendants are your sons and daughters.
Sons, daughter, and the wife.
5. Of defendant one.
Defendant.
Yes. What happened?
The father of the plaintiff and the defendant number one, Phanindra Burman, as per the plaintiff, had a plot of land of 46 acres long back. And Phanindra Burman died in the year 1980.
Okay. Okay.
Leaving behind 2 daughters and a son.
Hmm.
The son was adopted.
Son means you.
My
A1.
the defendant one.
Oh.
And 2 daughters. Another daughter is arrayed as pro forma defendant number 2 in the suit.
2 daughters and son adopted.
Adopted. So the
Okay.
father had 46 acres of land, your Lordship, as per the plaintiff. And the plaintiff says there was a family partition in the year 1985 after the death of the father. As per the family settlement, certain share of land was divided among all the legal heirs. The plaintiff's case is the defendant number one got his own share, he sold his share, and thereafter he was permitted to stay in a plot of land measuring 1 katha and 5 lesa by the plaintiff.
Apart from his share, which he has sold,
Which he has sold.
he was staying in a plot of land of
In 1 katha 5 lesas.
one katha 5 lechas.
Right. Then the case of the plaintiff is that in the year 2017,
Hmm.
he tried to further encroach on 3 kathas 15 lesas from the adjacent land which belongs to the plaintiff.
Which 3 katha
15 lesas
of plaintiff land.
of plaintiff. This is the suit land, your Lord. So they have paid for right title interest over this 3 katha 15 lesa along with prayer of eviction, your Lord.
And this suit land of 3 katha 15 lecha had gone to the plaintiff as per the family settlement.
As per the family settlement, according to the plaintiff's version.
Okay, what is your
The
version?
defendant filed the WS and the pro forma defendant filed the WS as well.
This is other
The
system.
other system.
Okay.
Both the pro forma defendant and the defendant stated there is no encroachment and there was no family settlement at all.
Both.
Both. But since there was no claim against the pro forma defendant, he did not come and adduce evidence.
Okay.
He filed the WS only.
Even.
And
What
there-
was her arraying as parties number, defend number?
the plaintiff is annexed.
The sister?
Plaintiff is annexed as 54, page 54. That sister was simply written as pro forma defendant. Damayanti Bala Burman,
Even pro forma defendant.
pro forma defendant.
Okay. Sister also supported the case of the defendant.
Supported the case of the defendant. The contention of the defendant and the pro forma defendant is there was no family partition.
Okay.
The claim of the plaintiff of the family partition, there was no, admittedly, there was no document of partition in it, but the name of the plaintiff was mutated in respect of 4 bighas of land.
Was there any document of family partition?
No, there was no document.
No document.
No document. So they have pressed their claim on the basis of the mutation.
Mutation was done on the strength of what?
There was no mutation order produced. Your Lord.
No, mutation, there was change in the names. Mutation was done,
Yes, Your Lord.
but on the strength of what?
There
What
was-
order? No order.
No order was produced. Mutation order was not produced. The Jamabati,
In the mutation, what the name of the plaintiff was
only the
there?
name of the plaintiff was recorded in respect of 4 bighas of land.
Okay.
The defendants also in their written statement has placed that they have came to know about this mutation subsequently. As such, they could not challenge the mutation. And they could not file a counterclaim to the same suit because the entire 4 bigha, the jurisdiction will exceed. So did not file a counterclaim against the mutation as well.
That is not a plea.
That
So
was
have
the-
you filed a separate suit in
No,
the
Your Lord.
court
The
with
separate suit
appropriate
was not
jurisdiction?
filed, Your Lord. However, a petition was filed before the learned circle officer that was kept pending during the period.
Petition for cancellation of mutation.
Challenging the mutation, a simple petition was filed. That was not brought on record by evidence as well. Your Lord.
Okay. Now,
So the substantial question of law that is proposed first, Your Lordship,
now what was the finding of the two courts?
findings was that there was an settlement, a family settlement, Your Lordship, though there was no agreement. The family settlement was perceived, Your Lordship, by both the courts below on the basis of the mutation. Because I did not produce any evidence to show that there was no family settlement. Your Lordship. This was the word of the title appellate court in page number 22, Your Lordship, which says, since it is not a suit for partition and the defendant could not prove that there was no family settlement, so the family settlement was assumed. Your Lordship. In a way, this, Your Lordship, the plaintiff's case was proved due to the weakness of the defendant's case. The presumption of the
Let us see that part.
page 22, para 16 of the appellate court judgment,
22.
page 20.
Yes.
As regard para 16, Your Lordship.
Yes.
As regards issue number 4, whether the property of late Phanindra Varman have been partitioned among the legal heirs, and issue number 5, whether the plaintiff has right title and interest over the suit land. Learned court below decided both the issues in favor of the plaintiff respondent, with observation that the plaintiff has registered his name in the Jamabandi since 1997 vis-a-vis the suit land as a co-heir from his mother Rambeshwari Varman, who earlier died, who earlier in the year 1983 inherited the land from the deceased husband, Lemni Phanindra Varman. Hence, keeping in view the instant suit is not being a partition suit and there is no evidence in favor of the defendant appellant, the issue number 5 was decided in favor of the plaintiff.
Ah. 17 you read?
17, the appellant took the plea that the plaintiff respondent could not produce any written document regarding the partition of the land left by the deceased Phanindra Varman and failed to state exact area of the land owned by the legal heirs of Phanindra Varman. Also, there is no any documentary proof regarding the sale of land by the appellant defendant Jatin Varman. The key point to discuss in this appeal is whether the plaintiff respondent was succeeded to prove his ownership over the suit land covered by DAG number 357 of PP number so and so of billet number 1. It is asserted that the plaintiff respondent, that the respondent number 1 sold his share of land and requested the plaintiff respondent to allow some land to reside with his family members. Accordingly, the plaintiff allowed a plot of land measuring 1 katha 5 letters covered by DAG number so and so. But in the year 2017, the appellant defendant have encroached the suit land measuring 3 katha 15 letters covered by PP number so and so, DAG number so and so of village so and so, alleged to be the property of the plaintiff respondent without his knowledge. Hence, the plaintiff respondent filed the suit for declaration of right title interest and for the eviction and delivery of past possession of the suit land against the defendant plaintiff. The claims are written here, and then
Okay.
then page 26, your lordship. 25, the para start, and relevant
You have
portion.
not framed any question on the finding of the family partition.
No, your lordship.
Don't you think that that should be a question?
Because the
See,
presumption.
the approach of the courts is tracing the right to the mutation rather than tracing the right to the origin of the mutation. Either it has to be a family settlement or some orders?
Question number 1, Your Lordship.
Yes.
Whether the plaintiff's reliance solely on the Jamabandi or mutation sufficient to prove her exclusive title over the entire plot of land. In this, Your Lordship, if we can add that without there being any written document as regards to the family partition. Because solely the mutation was taken care of. And another aspect of the matter here is that, Your Lordship, the suit was for eviction and declaration of right title interest. Even if we assume there was a family part, which we are not, even if we assume that, they have claimed that there is an encroachment of further 3 kathas of land. There was no issue framed, no evidence laid as regards to whether there was an encroachment or not. The issues that were framed by the court is at page 20, Your Lordship.
And what is the decree about?
Decree is about encroachment. There was an encroachment that was held, Your Lordship, without there being any issue or any evidence to that effect. Only as regards family settlement, there were issues.
Where are the issues?
Page 20. Part of the appellate court judgment.
20.
20. Para 11.
Okay. Whether the plaintiff has right title interest over the suit land, whether
5. The finding to that came in regards to the mutual settlement, family settlement, Your Lordship. Because the mutation was there, the court came to a finding.
so far as your framing of the first question is concerned, we may not have much of an issue. That the recordings in a Jamabandi mutation is not sufficient to go to the extent of deciding a title. That's not a title. But the other, what is the status now?
As it is, Your Lordship. There is an execution case that is filed recently, I've heard, Your Lordship.
Yes.
TX 4/23.
What is the position in
The next date is 4/7/24, but I think it's not proceeded. 4/7.
What is your IA for?
IA is for stay of the implementation.
In the appellate stage, it was stayed.
Yes, sir. Appeal was heard on.
No. During the pendency of the first appeal.
Yes, it was.
There was a stay.
There was a
This, please, while framing, or formulating, or drafting, or presenting an appeal of this nature, please do not address the court. Maintain the prescribed format. You should not address a court. It's a memo appeal. The present appeal has been preferred under section 100 of the Code of Civil Procedure 1908, challenging our judgment and decree dated 14/8/2023, passed by the learned civil judge, Senior Division, Chirang, in title appeal number 2 of 2023, affirming the judgment and decree dated 22/4/2019, passed by the learned Munsif Bizni, in title suit 09 of 2018, whereby the suit was decreed in favor of the plaintiffs. Full stop. The present appellants are the defendants in the suit. Full stop. Sri B.J. Mukherjee, learned counsel for the appellants, has submitted that the findings of the learned courts below towards declaration of right, title, and interest over the suit land is not based on materials and is not based on materials which are required under the law. And such title has been declared only on the strength of certain entries in the mutation. Full stop. It is also submitted that though such entries were claimed to be on the basis of a family settlement, comma, such family settlement was neither produced nor proved. Full stop. Para. The appeal is admitted on the following substantial question of law. A number 1 to the one will call it number 2 divide. Only one. Oh, that's not any other. Let's steps for service of notice upon the respondents be taken by usual process. Full stop. Steps within 3 working days from today. Full stop. List after 6 weeks along with service report. In the IA you write. By the instant IA filed under Order 47, Rule 5 of the CPC, comma, the applicant has prayed for stay of the impugned judgment and decree. So and so, it is submitted that the decree has been put to execution, and during the pendency of the first appeal, comma, the said decree was stayed. Full stop. Para. Let notice be issued in this application, returnable by 6 weeks. Let steps be taken for service of notice upon the respondents, upon the opposite parties by registered post with AD. Steps within 3 working days. Full stop. Para. Till the next date fixed, comma. Further proceedings in title execution case number
4/2023.
You have not even mentioned.
I came to know recently.
The impugned judgment and decree dated so and so shall remain stayed. Full stop. It is clarified that the Sri Mukherjee, the learned counsel, has submitted that he has recently come to learn regarding the institution of execution case number
4/23.
4 of
2023.
2023. Full stop. Para. As a consequence of the stay of the impugned judgment and decree, comma, the further proceedings of title execution case number so and so shall remain suspended. Full stop. The interim order passed today would, however, be reconsidered after appearance of the contesting respondents. Okay.
I take indulgence of the The second, I have a personal difficulty, I have to go to speedy good. So I have a item number 31 with my friend. So either it's two lordship or it may.
31 is what matter?
It's a
Malat,
CRP has been filed.
CRP we have filed, Malat, but the only question is that in the last time, Malat, this honorable court has given the interim order will be continued on the next reasonable date.
No interim order has been filed.
None,
Will be
not
considered.
passed, will be considered, Malat. That's
You-
why, Malat, because the execution petition is going on in the lower court. And if during the pendency of this case, Malat, if the execution.
Lawyer
petition-
court or lower court?
Lower court.
You said lawyer court.
Lower court.
It is now under the law, lawyer. So I have no difficulty.
That's why,
of
Malat, maybe
two.
taken number 2, Malat. Then.
If it is possible. I have no.
Are you considering for a stay?
No, because the
You
CRP
consider
is
you
not
go to-
maintainable.
You consider and go to Siliguri.
Yes, Malat.
We'll not record your concession.
Let the Malat status quo maybe maintain. till the
CRP is
next
not
date.
maintainable, that is the short question.
You go with a peace of mind to Siliguri. We'll pass an interim stay. All parties will be happy.
Yes,
Till you
Malat.
come back.
Yes, Malat.
At 2 Lord.
Let us see at 2.
Yes, yes. Much.
I have to pending থাকিব, huh? Yes.
Before placing on marital, they filed, there one compromise decree was drawn up by the court on the basis of a compromise petition filed by the party. Then
Okay.
thereafter, some of the defendants, they have challenged that compromise decree by filing an application under order 23-3 to the court. The court.
The defendants were parties in the compromise petition.
Yes, by an attorney. They have said that the attorney is not authorized.
Okay.
Be that it may, they have filed for a application for recalling the compromise decree
Correct.
before the court where the compromise decree was drawn up. That is permissible under law. Supreme Court says that you have to approach for recalling the court who has passed the order. Thereafter, the learned trial court has rejected their application of recalling the decree. They came up before this honorable court by under Article 227. Now, the question is, Lordship, that this appeal is lying against an order passed by the court. An appeal is lies under Order 43, Rule 1A. Earlier, Lordship, there is an provision of 43(2)M. M was deleted. In 1976 amendment. So you will find that 43 Rule 1M was deleted.
Yes.
And one capital A was inserted. One A, two Lordship can leader.
Please read.
Lord.
Right,
1A,
yes.
where any order is made under this code against a party and thereupon any judgment is pronounced against such party, a decree is drawn up. Such party may in an appeal against the decree contend that such order should not have been made and the judgment should not have been pronounced. Now, 2, in an appeal against a decree passed in a suit after recording a compromise or refusing to record a compromise, it shall open to the appellant to contest the decree on the ground that the compromise should or should not have been recorded. So therefore, then an appeal has to be preferred under Order 43 Rule 1A. And to this effect, 2 judgments of the Supreme Court is approved this.
Oh, irrespective of the fact that they had filed an application for recall, you contend that against the original decree,
Yes.
in spite of that being a compromise decree, they can prefer an appeal under this
Under
amended
this-
provision of law.
And I am relied upon a two judgment of the Honorable Supreme Court.
Mr. Deka, what is your reaction?
My lord, it is clear by the Supreme Court, my lord, recent judgment, my lord. I am reading, my lord.
On the maintainability where,
Yes,
yes.
yes, my lord. It is clear, my lord. May I read, my lord? I am first reading the head note, my lord.
Yes.
Or he is also in a hurry, my lord.
Hmm.
Code of Civil Procedure Code 1908,
Hmm.
Order 23, Rule 3, and Order 43, Rule 1A. An aggrieved person against the compromise decree has a right to file an application before the court which granted the decree. He has the right to avail either the remedy of
It is
appeal,
maintainable.
my lord.
It is maintainable.
It is maintainable.
No,
my
no,
lord.
the court has rejected on the maintainability ground or on merits?
No, no merit.
No merit, my lord.
That part
Let
is
me-
closed.
Oh.
Now, what is the remedy?
Okay.
You have to challenge the compromise decree. Then compromise
First-
decree cannot be
May I
challenged.
submit, my lord?
No, no,
May I submit?
no, no. If he's aggrieved by a rejection of an application,
Yes.
which is permitted by law, then he has to have a remedy.
Yes, my lord.
That that recourse of his cannot get over.
They have, before this honorable court, against composite, that decree as well as rejection. They have filed this, challenging the decree also. Decree
Oh.
cannot be challenged by way of a revision.
No, my lord. No, it
Are you
is-
challenging the decree here?
No, not decree, my lord. Decree is along with that, my lord. Because, my lord,
No,
it
we
is
we
clear,
can,
it is clear. my lord.
if Vin has put the decree to challenge, we can clarify that this challenge will be restricted to the
Yes,
rejection order.
yes, my lord.
For
My
that,
lord,
I think
the-
this maintainability will not be an issue.
Yes, my lord. It is either way. We have taken the clear appeal or by petition under order 23 A, my lord, proviso. Our petition itself is.
Then let us see how you have structured your
Yes,
present
sir.
petition.
Prayer portion kindly see that.
Let us see the cost item first.
My lord, before this ruling, my lord, this ruling itself says that either we can prepare an appeal or petition under section of 23, 23C proviso. my lord. Our petition is particularly proviso. my lord.
No, we are not on the maintainability of your petition there.
Yes, my lord.
No.
We are
So-
on the your
ma'am.
course of action
Yes.
in approaching this court as a revision court
Yes, my lord.
against the order of rejection as
Yeah.
well as you have impugned
Yes,
the
my lord.
decree.
We'll have to, because that is the compromise decree, my lord. Decree is compromise decree by a power of attorney holder who was not
Then decree, can you put it in a in challenge in a revision?
revision, because each compromise decree is gone, my lord, by this way of this revision,
21,
then automatically it will go, my lord.
20.
Otherwise, my lord,
No, we will examine the correctness of the order of rejection,
yes, my lord.
not the decree. If we interfere with
Yes.
the order of rejection,
ma'am.
you get your
Yes.
remedy.
Yes, my lord.
Sir, kindly peruse para 2041. Very clear, Supreme Court said.
No, but he cannot be, you cannot
Yes, sir, remedialist. I am
make
not-
him remedialist
No,
against an order.
not immediately. He has to file an appeal.
No, no, appeal is against the decree. But towards his prayer for recalling of the decree, his
His prayer is, because Lordship is, kindly see that the prayer is against because they have to challenge the decree. Because the decree has been drawn up on the basis of a compromise. Lordship kindly have a look at prayer.
Mr. Decker, the first prayer I think will not be proper.
My lord,
How can you challenge the judgment and decree of 7/7 and
my
10?
lord, because we
No,
have
no.
the impure order that is particular. Yes.
That
Yes, ma'am.
we'll restrict to that.
Yes, my lord.
We'll
Yes.
restrict to that.
So, my lord, now, my lord, they are.
Degree cannot be stayed, that is the whole problem by
Degree-
the petitioner. Because once you decree, you cannot file an appeal, how could the decree can be stayed? That is their problem. So I cannot advise them, your lordship. So it is up to them, liberty upon them to
My
file
lord,
an appeal.
they are filed execution petition, my lord, on the basis of the compromise. In that particular compromise, there is a monetary benefit also there, my lord.
Now, why didn't
So-
you file prefer a regular appeal?
My lord, because in the presence of this particular compromise decree and petition, my lord, by the attorney holder, would have this authority. Although,
No. Why don't you prefer a regular appeal?
That
my
is
lord,
the way.
my lord, because, my lord, we cannot file a regular appeal.
Why?
Because the bar on order of 1996, my lord, fee, there is a compromise decree.
And
No,
earlier.
no, no,
Let us clarify.
no, no,
That part we know.
the clarification is given. You have made out a case on facts that the power of attorney was not even authorized by you to enter such decree.
Because 96(3) bar. the
You
Supreme
can
Court
challenge the
clearly
decree
clarified.
by way of an, we are not here to advise you by way of an independent suit itself.
Yes, my lord.
If you are alleging fraud,
Yes,
Yes,
my
there is
lord.
no bar also.
My lord, 1M, earlier there is a order 43 rule 1M. There is a,
1M has been taken away by
Taken away.
76 amendment.
that was
Yes.
provided for appeal, my lord, against the order.
Therefore, 1A
So, my
come.
lord, 1A come. So we can opted by either order 23 proviso or appeal, my lord. We have opted that against that order. He passed the order without going through the fraud or reading without taking any evidence, particularly when I have. raised the
That
question.
order, that rejection we will be examining, we'll
Yes, my
examine.
lord. That is, my lord.
I heard 3 PS declared senior counsel for the petitioner, assisted by Sri R. Islam, whereas the respondent for
1 to 5.
all the respondents,
He appear.
respondent numbers 1 to 5 are represented by Sri B. Dutta, assisted by Sri S. Deka, senior counsel assisted by S. Deka, and respondent number 6 by Sri P. J. Sekya, learned counsel. Say 6 and 7. 6, A.K. Gupta for respondent number 7. Para. The present application has been filed under section 115 of the CPC, read with article 227 of the Constitution of India against an order dated 5/2/2024 passed in mid-J case number 49 of 2023 arising out of TS number, title suit number 36 of 2019 by the learned civil judge, senior division Tinsukia, whereby the said petition filed by the petitioners who are the defendant numbers 2 to 6 in the suit under proviso to rule 3, order 23 of the CPC for recalling of the compromise decree, compromise judgment and decree has been rejected. Full stop. Para. This court has, however, noticed that in the relief claimed, the compromise decree itself has been prayed to be set aside, which perhaps cannot be gone into by a court exercising revisional jurisdiction. Full stop. Be that as it may, the legality and correctness of the impugned order dated 5/2/2024 can be a subject matter of adjudication, subject matter of scrutiny by this court. Full stop. Para. First time it has come. First time. Issue notice.
Notice already issued, my lord.
No, not issued.
15.
Caveat, we have on caveat.
15/5/2000.
Oh, notice was already issued. Then why is it today?
No interim order was passed because of the maintainability.
Because, my lord,
Okay.
you consider on 15.
You are praying for an interim order. Are you going ahead with the execution?
Yes, yes.
Yes, Lordship, the decree cannot be, Lordship is the appreciate. But how could the decree can be stayed? Because of the fact that he has to file an appeal and that order may be taken up by the appellate court.
Para, notice was issued in this case on 15/5/2024. And an observation has been made, was made that the prayer for interim order would be considered on the next date. Full stop. Para. Sri Deka, the learned senior counsel for the petitioners, has submitted that the compromise decree is an outcome of a fraud played by the by the respondent number?
Respondent, all respondent, they are also.
No. Who is the power of attorney?
Six.
Is an outcome of a fraud which has been done by the respondents in collusion with the so-called power of attorney of the present petitioners. Full stop. This court is of the opinion that since fraud has been alleged, comma, interest of justice may require some protection to be given to the petitioner. Full stop. At the same time, comma, this court has seen that the decree as such is not the subject matter of challenge till now in any appeal. Full stop. Therefore, while this court is inclined to give some interim protection till the next date fixed, comma, let the entire matter be taken up for final consideration on the next date.
On 25th.
On the next date.
By any court date.
On the next date. Full stop. Till then, comma. Further.
Lordship, I'm just a request, I'm saying that we will not go further because of the fact.
Can you record your statement?
Yes. Because of the stay, that is a contradiction of the law, Your Lord. That's the problem.
Full stop. At this stage, comma, Sri Datta, the London Senior Counsel for the respondent numbers 1 to 5 has undertaken that till the next date fixed, comma, no further steps will be taken in the execution case.
Lord.
Full stop. Considering the said statement, comma, while consider state statement, comma, list this case for consideration on
25th, Lord. Yeah, June.
25th June will be last week, will be
Oh,
difficult.
yes, difficult. Then 23rd of July.
Yes, on 23rd of July, on which date an endeavor will be made to dispose of the petition itself.
Problem.
Interesting point.
One judgment we have produced.
Mr. Deka, you can also take your petition.
Yes.
Take your, one.
We remain, my lord, we have extra copy.
Okay.
Remain in file, my lord.
Typing. Yes.
Lordship, this application is under section 24.
That we have seen.
Lordship, main ground of divorce is, Lordship, I have filed two petitions, two cases are pending in Dibrugarh, Lordship. This is the main ground. Cruelty is the main ground, Lordship. Lordship, grounds for transfer, Lordship, I have no financial support, Lordship. And I'm living with my elder sister, Lordship. And secondly, Lordship, it is not possible for me to travel from Dibrugarh to Guwahati, Lordship. And
You can
thirdly,
have video conferencing. There's a scope of video conference. You have filed two applications there in Dibrugarh. How is he conducting? He is going to Dibrugarh. What has happened to those proceedings? Your cases, you said you had filed two applications, one domestic violence, one under what?
Lordship, same petition, Lordship.
One for return of Sridhan.
Sridhan, Lordship.
He is contesting those cases. He is having to travel from Guwahati to Dibrugarh.
Lordship, he has no one to accompany her, Lord. He is alone, Lord.
When is the next date?
Lordship, today is the date, Lord.
In Guwahati?
Yes, Lord.
What is your source of income?
Lordship, I don't have any source of income.
Do you have any issue, any child?
No,
No. How do you survive?
Lordship, I am living with my elder sister. I am dependent on,
You don't do anything.
yes.
And your husband?
He is working in Guwahati, Lordship, in a farm.
What firm?
Lordship, in
As what?
Lordship, in share broker from Lordship.
As what?
As what I say, Lordship, not mentioned here, just working in a share broker from Lordship.
As what? We need to know. How much is he earning?
That is not mentioned here, Lordship, in his divorce petition.
We may not consider your interim prayer. We'll issue notice at this stage. Let him come. Can you serve dusty upon him?
Yes.
Hmm?
Yes.
Let us see the application for. Have you contested the application? Have you filed a written statement in Guwahati? Have you appeared?
No, Lord.
You have not appeared. How do you know that today was the date?
I have Lordship, there is a judgment. My senior instructed me to fix the judgment.
No, you say that 7/3/2024 notice was issued in the reverse petition. 7/3. And thereafter you had received notice. Have you appeared before the court?
Yes, Lord. He
Have
has
you filed
appeared.
written statement?
No, Lord. Today is the first day, Lord.
We'll issue notice at this stage. Can you serve dusty upon the respondent? No. Take heard. What is your name?
M. Deka, on behalf of SDK.
Heard, Miss M. Decker, Learned Counsel, for the petitioner who has filed this petition on 24, filed his petition under section 24 of the CPC, read with Article 227 of the Constitution of India for transfer of FC Silaba from the court of this principal judge, family court number 2, Kamrup M, to the court of the learned district judge, Dibrugarh, Riverside of Coastal Local. Full stop. It is submitted that the you want to Dibrugarh. Where are you staying now?
I'm staying in Dibrugarh, Lordship, with my elder sister.
But marriage was at Tinsukia.
Yes, Lord.
It is contended that the petitioner is presently staying at Dibrugarh with her elder sister. Full stop. It has also been submitted that the petitioner had instituted two proceedings before the two proceedings at Dibrugarh against the respondent, one under the Domestic Violence Act and the other for return of the Stridhan. Full stop. Para. It is seen that notice was issued in the impugned proceedings on 7/3/2024, fixing the next date as today. Full stop. Para. Let notice be issued returnable on on 15th of July 2024. Let steps be taken for service of notice upon the sole respondent by registered post to AD. Steps within 3 working days. Full stop. The prayer for interim order would be considered on the next returnable date on appearance of the contesting respondent. Okay. Take steps immediately. We'll see next date.
Highly object.
May I please? This is second appeal, my lord. This is a judgment of reversal, my
Okay.
lord. We have formulated additional substantive question of law. My lord, in this suit, my lord, the question regarding the give deed, my lord, exhibit 1, which is a 30 years old document, my lord. That document was not presumed under section 90 by the trial court due to the fact that there is an earlier suit, my lord, and in that suit a judgment was passed that the donor, he denied the execution, my lord. So taking that judgment, my lord, he did not exercise his discretion under section 90, my lord, to presume the genuine document. That was reversed by the first appellate court, my lord.
Did you say judgment?
Yes, ma'am. That was reversed by the appellate court.
Okay.
Against that we have come. It was below the same family member, my lord.
Just a minute. Just let me make some notes. Appellants are the?
Appellants, my lord. Appellants are the son of.
No, are the plaintiffs?
We are defendant, my lord. We are defendant.
So
we
it was for?
We are son of the donor, my lord. LS donor. And they are the son of, my lord, the
beneficiary.
Beneficiary Dhoni, my lord. The father of the plaintiff and defendants are brother, my lord. Defendant number 1 and 2. They are brothers, my lord. So father of the defendant, allegation is that the father of the defendant executed a gift deed in favor of her sister-in-law. The mother of the
suit was for what?
For declaration of right title interest and regard for possession.
On the strength of the sale of the gift deed.
Gift deed, my lord. During the lifetime of the donor, my lord, there is a suit filed by one Kulcha Ali, my lord, claiming that he purchased the land from the mother of the plaintiff on the strength of that gift deed, my lord. That suit was initially decreed, my lord. We prefer appeal, and appeal, my lord, that suit was dismissed. Because
what was that suit?
My lord.
What was that suit?
Suit, my lord, that suit, my lord, title appeal is 4/96. That was appeal is filed by us, my lord, our father. And title suit was, my lord, title suit number 34/88, my lord. And in appeal, my lord, the learned appellate court, my lord,
date?
My lord.
Date,
my lord.
That appeal was allowed?
Appeal was allowed, my lord. 11th of December 1995, my lord. Decree was drawn up. Suit was drawn up, my lord.
No, suit was decreed by the appellate court.
The suit was, my lord, rejected that.
Okay. Your appeal was allowed. The appeal by your father was
yes,
allowed.
that in the, my lord, judgment.
And in the title suit of 34 of 88, what was the suit for?
Suit for, my lord, right title interest, declaration of right title interest by one Pulsa Ali, who is the purchaser of the land on the basis of the, from the mother of the, that is Doni, mother is the Doni Miller. On the basis of that, my lord, give the, is up into the suit, my lord, for the declaration of right title interest that was decreed. Subsequently in appeal, that suit was dismissed, my lord.
Suit was initially decreed.
Yes, ma'am. Initial decree in favor of the Pulsa Ali, who is the purchaser from the mother mill.
The Doni.
Doni mill.
Okay.
So taking the that ending of the suit, my lord, that there was a appellate order, my lord. The court did not take any presumption by of discretion.
Yes.
And rejected the section 19 presumption of the document, my lord.
Okay. Okay. And the appellate court?
Appellate court rejected that.
On what is the
It is binding, my lord. It is a 30 years document, so it is binding.
no, the presumption was rebutted successfully.
Yes, my lord.
And there is a decree by
Appellate court.
competent court which has attained finality.
Yes, ma'am.
So the decree, the gift deed was not
my lord.
not valid in the eyes of law.
Idea of law under section 90, my lord, but they can prove the document by resorting the provisions of order 68, 69.
No,
By-
that is a different
yes,
aspect, but
yes.
presumption is not available.
Not available. That is
And even how far they will be successful in proving a document which has already been held to be
yes, ma'am.
non-operative by a decree
Yes.
which has been attained finally, that's
Yes.
also another question in your favor.
Yes, ma'am. That is.
Okay.
So, my lord, we have formulated the subsequent question, my lord.
Yes, where are those?
Number one, whether
Additional.
whether interference by the learned first appellate court in respect of the finding arrived by the learned trial court in its refusal to take presumption of exhibit 1 under section 90 of the Indian Evidence Act by exercising its discretionary power under said provision is sustainable in law.
Now, I think we'll have the second additional substantial question to be the substantial question. This
Second.
will be the second one, whether the impugned judgment or reversal,
Yes,
it should be whether.
yes,
Is
ma'am.
bad for non-appreciation of the materials available on record, more particularly materials of the earlier title suit and title appeal of 4.
Yes, ma'am.
Okay.
There is another substantial question.
And in the earlier title suit 34 of 88, your predecessor was a party
Yes, ma'am.
and he had preferred the appeal,
Yes, ma'am.
which was allowed,
Yes, ma'am.
and the suit was dismissed.
In the present defendant also party, my lord. We have an
Okay.
heard. My lord, another substantial question we have formulated in the body of the appeal memo, my lord.
Which one?
My lord, B, my lord. Page 10, my lord.
How is your additional substantial question of law, number 2, different from the first question which you framed earlier, number A? I think that will cover everything.
About reading, my lord, but earlier court said you reframe that is why.
No, I think A is better.
Yes, my lord. Yes, ma'am.
Heard P.S. Dekal and senior counsel for the appellant assisted by Sri Bhagavati, learned counsel, who has preferred this RSA under section 100 of the Code of Civil Procedure 1908 against the judgment dated 1/12/2023. এখানে করি in the first title of since by the impugned judgment, comma, the learned first appellate court has invoked the provisions of section 90 of the Indian Evidence Act.
Yes.
with regard to a gift deed, which was the basis of making the claim in the suit. Full stop. It is contended that in an earlier proceeding, being title suit number 34 of 1988, wherein the subject matter was a sale of the land arising from the title allegedly transferred by the same gift deed, comma, there is a judgment by the First Appellate Court dated 11/12/1995, wherein the gift deed was held to be inoperative. Full stop. Para. It is submitted. No, actually, it is submitted that the aforesaid aspect has been overlooked by the learned First Appellate Court in the impugned judgment and decree. Full stop. Para. The appeal is admitted on the following substantial question of law. Page 10. Earlier title suit number so and so 34 1988, and also we'll just add one, and also the judgment and decree dated 11/12/1995 passed in title appeal 4 of 1996. Any other question, to the attorney? Let steps be taken for service of notice upon the respondents by usual process, steps within 3 working days. You have IF4?
Yes, payment.
What is the stage?
My lord, they have not filed.
Any execution?
No, not as per our instruction.
Okay. Heard Sri PS Dekalan Senior Counsel, assisted by Sri BK Bhagavati, learned counsel for the appellant, who by means of this application filed under Order 41 Rule 5 of the CPC has paid for stay of the impugned judgment or order, first report. So this court has, however, been informed that till date, to the knowledge of the applicants, no execution case has been filed. Full stop. Para. The I is therefore deferred. The consideration of the I is therefore deferred, and would be made as and when any such execution case is filed. Yes.
My lord, this is concurrent finding against the appellate. But we have a case on merit. Lordship, the respondents are Jiten Bhengra.
You are who?
I am appellant defendants.
Appellants are?
We are appellants defendants.
You are defendant in the suit. Suit for?
Suit for partition and eviction.
Okay, then what had happened?
My lord, here the respondents were the plaintiff before the court below, Jiten Bhengra and Srimati Pinky Bhengra.
they claim to be the son and daughter of late Shukram Bhengra. Actually, this respondent number 2, Bina Bhengra, is the daughter of Shukram Bhengra. But 1 and 3 are not the biological children of late Shukram Bhengra.
Daughter is? Who's the daughter?
This is respondent number 2, Bina Bhengra.
Bina.
Yes, she is the biological daughter of late Shukram Bhengra.
Okay, and the
But
present
1 and 3, they are not the
1 and 3.
1 and 3.
Who's 2? 2 is Bina.
2 is Bina, yes.
Okay.
1 and 2, 1 and 3.
They are not the biological sons and daughters.
No, yes. They are the son and daughter of one Bahira. Now, after the death of wife of Shukram Bhengra, this Bahira came to the house of Shukram Bhengra with these 2 children.
Bahira is
Bahira is on 3rd lady. 1/3 lady after the death of Shukram Bhengra's wife, this Bahira, a lady who was also a widow, she came to the house of Shukram Bhengra and stayed with him like a husband and wife. But they are not this Jiten Bhengra and this Pinky Bhengra. At that time, they were nearly 4 to 6 years of age.
they are the step children.
Not step, yes.
Step
from
children.
different father.
Step children.
No. Shukram Bhengra's Bahira and Shukram Bhengra lived together as husband and wife. At that time, they were 4 and 6 years old when she came to the house of Shukram Bhengra. So they are not the biological son of.
Understood. So there will be the stepchildren of Shukram, not his own children.
Yes. Now the property belongs to Shukram Bhengra.
Okay.
After his death, the properties were inherited by Maji Bhengra. Maji Bhengra is the daughter of late Shukram Bhengra. Maji Bhengra and Bina Bhengra, their own sister.
Yes, they are daughters of Shukram.
Shukram, yes. Now, Maji Bhengra has died. So, the 1, 2, and 1, 3, they are the daughter and son of Maji Bhengra. So, they are the appellants in this.
Maji has two sons and daughters.
No, Maji has 2 daughters. So yes, 1 daughter, 2 children, 2 sons. Who are appellant number 1, 2, and 1, 3.
Now these 2 sons and daughters are the plaintiffs.
Are the plaintiffs' appellants here?
No, appellants are you are the defendants.
Here we are appellants, defendants.
Yes. Who are the plaintiffs?
Plaintiffs are this Jiten Bhengra, Bina Bhengra, and Pinky Bhengra. They are the plaintiffs. Now, our clear case was that the Jiten Bhengra and Pinky Bhengra are not the biological son of Shukram Bhengra.
R1 is Jiten.
Yes.
R1 is Jiten. And R3 is Pinky.
Yes. They are not the biological.
But Bina is also with them.
No, Bina is with them because she sold her shares and she came only to create some property. So she was.
You claim that you are the biological sons of Shukram.
Yes.
Shukram.
Yes. Now, our clear case was that this Jiten Bhengra and Pinky Bhengra are not the son or daughter, biological daughter of late Shukram Bhengra. They are not the legal heir.
Okay.
They have no locus standi. But One thing was, my lord, perhaps not properly conducted. No DNA test was called for, so that was necessary in this case. Now, our submission is this, my lord. As per section 101 of
He had
Indian
filed a suit for partition and eviction.
eviction.
What had happened there?
Then the learned trial court hold that, no, this Jiten Bhangra and Pingi Bhangra are the son and daughter of late Shukram Bhangra.
No, in the partition, you had also sought their eviction. Okay, it was denied.
The eviction means we are possessing the land. So that's why they filed this partition, thereafter eviction.
Suit was dismissed.
Suit was decreed in favor of Jiten Bhangra. It was decreed.
Oh, they had filed the suit.
They have filed the suit.
So they had sought your eviction.
Yes. From the land of our father, this is Shukram Bhangra.
Why was the eviction? On what was the strength of praying for eviction? If you are also the children of Sukram?
Yes, that was they filed. That partition should be there. Shukram's land should be partitioned. And they also admitted that we are also the legal heirs, but they also claim that we are also legal heirs. In that view, they wanted their share, partition of the land of late Shukram Bhangra, and thereafter to evict us from that land.
No, if they're admitting that you are also the sons and daughters of Sukram, and they are also praying for a decree of partition.
No, they did not claim whole thing.
Question of eviction from which land? Eviction presupposes that you are in illegal occupation of their land.
That is Schedule 1, my lord. Schedule 1 land may be seen, my lord, page 18.
So suit was decreed.
Yes, page 16 it is that. Suit was decreed. Suit was filed by Jiten Bhangra, that is from page 8 may be seen.
Then appeal also dismissed.
Appeal was also dismissed. But our claim is this, my lord. When Jiten Bhangra and this Pinky Bhangra, they want that we should be declared as the son and daughter of late Shukram Bhangra. 101 of Indian evidence says that one who wants to get some order from the court, it is their duty to prove the same. It is a debatable issue, but that was not discussed. That was not properly discussed by the learned courts below. And our case was that they are not the son and daughter of late Shukram Bhangra. Now each of the parties deduced 3 witnesses. Even their own witnesses also supported tacitly our case, my lord. That lordship may kindly see here, page.
Now, what are your substantial questions?
Our substantial question we have formulated in our petition itself, my lord. That may be seen, my lord, page 4. Here the neighbor also gave a witness, Kamiba Dahanga. He also said that they are our neighbor and I know that they are not the son. So that is
page 4.
1. We have formulated 4, but I think, my lord, 1.
Page 4.
Page 4 of the arrest.
Okay. Please read.
Whether the learned trial court as well as the first appellate court were correct in deciding the issue number 4 that Jiten Bhangra and Pingi Bhangra are the legal heirs or successors of late Shukram Bhangra, being his son and daughter, which have been specifically denied by the appellants, their witnesses, including one villager, namely Kamiba Dahanga, all of whom specifically adduced that Jiten Bhangra is the son of Srimati Bahiri through another man, when their evidences could not be demolished by respondents, and the same has also been tacitly admitted by Shahanur Islam, PW3. So Shahanur Islam is their own witness. Then lordship may kindly see para 2, substantial question number 2, whether the learned trial court as well as first appellate court were correct in holding that the respondents have also the right, title and interest over the A and B scheduled land, when the respondent number 1 and 3 have been miserably failed to prove that Jiten Bhangra and Pinky Bhangra are the son and daughter of late Shukram Bhangra, the burden of which lies upon them being the claimant and beneficiary of the suit land. Then third may not be necessary, but fourth is necessary.
But there were specific issues, being issue number 4 and 6, that
My lord,
whether
it's-
plaintiff number 1, Jiten Bhangra,
Issues were found out, my lord, but
is a legal heir
issues
of
have
this.
been discussed in a wrong manner because, my lord, I have wrote some citation for your lordship kind perusal that may be seen here.
I have considered one.
We have a fault, my lord, we did not pray for a DNA test, but that's in this regard, our
But,
High Court has
he had the prima facie, he has discharged the onus.
no,
The
discharged-
burden has shifted upon you, but there's a clear discussion in at page 35. He had, this Jiten had produced certain documents,
Yes,
namely PAN card,
yes.
bank passbook, school certificate to prove his identity.
All these are later on he made. After death
But
of
the court
Shukra.
has also gone to the extent that once he has discharged his initial
No, my
burden,
lord,
the
my
onus should
submission is
shift
this-
upon you.
No, my submission is this, my lord. First thing is there is no birth certificate. And birth certificate should be within 1 year. Otherwise, that should have been duly permitted by the deputy commissioner or district commissioner. So birth certificate is not here. All the other documents are subsequent production. So those are the very debatable issue. So when there is a debatable issue and that is itself is a substantial question of law.
No, if he has discharged his initial burden, onus shifts upon you. What did you do? As a
No,
defendant, if
no,
you are
my
making an
evidences are-
allegation,
My evidences, my lord, I have adduced 3 witnesses that lordship may kindly see page 41A. First, there witness Jiten Bhangra, Maidul Islam has not supported nothing she has supported. And then Mahanur Islam, he is the Mondal. Mondal could not produce any document that in that land, the name of this Jiten Bhangra is recorded. So that is one aspect of the case. Second thing, my lord, we adduced witness Srimati Chini Bhangra. Chini Bhangra is the daughter of Shukram Bhangra, Maji Bhangra, whose mother is Maji Bhangra's daughter is Chini Bhangra. So Chini Bhangra adduced her witness. Then summarily witness and Kamiba Dahanga. Kamiba Dahanga is from their tea garden community. But these other persons are not from tea garden community. So this Kamiba Dahanga clearly stated that these 2 persons are of Bahiras and she came with these 2 boys to the house of Shukram Bhangra, lived together. But at that time, there was 4 to 6 years of age. So why that should not be believed? So, my lord, so far regarding DNA test, my lord.
can there be a substantial question of law?
Yes, my lord, that can be a substantial question.
We are
of-
in the second appeal. First
My
appeal,
lord.
first appeal, no
No, my
problem.
lord, I am on first appeal, second appeal, my lord. It is our 2003 2 GLT. I have given the citation.
2003, yes.
2003 2 GLT 368 para 7 and 8. Even during the second appeal, amendment prayer may be also allowed. So
Amendment prayer.
amendments to the extent of this DNA test, that is later on. And not
Where
at
is your
this stage.
amendment prayer? Where is your prayer for additional evidence at the
No,
appellate
additional
stage?
evidence, my lord, that has not
You
yet
have not
come. I
filed
understand
the
that.
41,
But thing
27.
is this, my lord, first one, non-consideration of oral evidence.
Yes.
and documented evidence properly may be also a ground of second appeal. Moreover, if the finding is manifestly unreasonable and unjust, court will interfere in the second appeal.
Which is the ground? Okay, these are the.
Yes, my lord. The Dahanga
Which question will come under this? The law which you have just narrated. Which of
wrong
the
reading or misreading of evidence.
No, which question of yours will come under that?
Question means Dahanga.
No, which substantial question? You have frames at page 4.
Yes.
Which one will come?
Yes, that will come, my lord. That will come, my lord. One will come, my lord. One, and land is not protected Bina Bangra.
Please read one. Can it be
One.
a substantial question? of
Whether
law?
the learned trial court as well as the first appellate court were correct in deciding the issue number 4 that Jiten Bhangra and Pinky Bhangra are the legal heirs of or successors of late Shukram Bhangra, being his son and daughter, which have been specifically denied by the appellant. Their witnesses, including one villager Kamiba Dhanga, all of whom specifically adduced that Jiten Bhangra is the son of Trimati Bahiri through another man, when their evidence could not be demolished by respondents, and the same has also been tacitly admitted by Shahanul Islam, PW3, their own witness panel.
Let us see the discussion of PW3.
PW3.
Who is PW3? And regarding your submission of DNA, unless you filed 4127 application at this stage, how can you
My
go
lord,
into
that was
those
our
aspects?
prayer that if your lordship kindly admit the appeal, then we will file that petition. Unless there is an existence of appeal, how you can file a petition?
Why not? You can accompany this petition with a prayer for adducing additional evidence. We may consider.
Additional evidence, yes, that may be filed.
But substantial question of law has to be
Additional
there. This
evidence
is-
or 138
this-
would also come.
This is
But
the
our
second-
intention
second
is
appeal.
that
Let us see
first
the discussion on PW3.
3.
Page.
PW. In the first title suit, my lord, trial court,
Yes.
I do not see whether this evidence has been discussed. If that be so, that is also a ground for second appeal, my lord. Forum 29, it starts discussing the witnesses, the case of defendant number 1 and 2, and
Now, if you have made that ground, kindly show from where it will appear that the Latmandals.
yes, that copy is with me.
Please hand it over.
The two witnesses are here. One is
Just read out the Latmandals evidence.
Latmandal.
The part which you are relying upon.
Yes. It is long discussion, my lord. May I read the whole?
Only the relevant part.
Long statement.
Only the relevant part.
Yes. Relevant portion. মই সমনখন আদালতত জমা দিছো, সেয়ে গোচৰৰ নথি দেখা নাই। প্ৰদৰ্শক 15ত যিসকল পত্ৰধাৰৰ নাম অন্তৰ্ভুক্ত আছে, সেইসকল পত্ৰধাৰৰ কোনোজনৰ সঠিক অংশবিলাক বিশদভাৱে উল্লেখ কৰা হোৱা নাই। প্ৰদৰ্শক 15 10 নম্বৰ কলমত অৰ্থাৎ মন্তব্যৰ ঘৰত যিয়ে মেধি গোচৰৰ বিষয়ে উল্লেখ কৰা হৈছে, সেই মেধি গোচৰৰ মূল নথি মোক সমনত আনিবলৈ নিৰ্দেশ দিয়া নাই আৰু সেইবাবে মই অনাও নাই। একেদৰে 15 উল্লেখ থকা সংশোধনী নামজাৰি গোচৰৰ নথিত মই আজি সমনত জানিবলৈ নিৰ্দেশ নথকা বাবে লৈ অহা নাই। পদক্ষেপ 15(1)ত উল্লেখ কৰা পদক্ষেপ ক নামজাৰিৰ টকাটো কোনো নামজাৰি গোচৰৰ ভিত্তি কৰা হোৱা নাই। পদক্ষেপ ক টকাটোত পট্টাদাৰ শুক্ৰামৰ স্থলত শ্ৰী জিতেন বৰাক আদি কৰি অন্যান্য যিসকল পট্টাদাৰ উত্তৰগী সূত্ৰে নামজাৰি দেখুওৱা হৈছে তেওঁলোকৰ উত্তৰাধিকাৰী হোৱাৰ কোনো সাক্ষ্য প্ৰমাণ গাঁওবুঢ়া বা আন কোনো স্থানীয় দায়িত্বশীল ব্যক্তিৰ পৰা লোৱাৰ কথা জবানবন্দী আৰু চিঠা 16(1)ত উল্লেখ নাই। যেহেতু পট্টাদাৰসকলৰ 15(1) আৰু পদক্ষেপ 16(1) মতে নিজ নিজ নামৰ অংশ বিভাজিত কৰি দেখুওৱা হোৱা নাই, গতিকে কাৰ কিমান অংশ হ'ব পাৰে বা কোনে কিমান অংশ হস্তান্তৰ কৰিব পাৰে সেই বিষয়ে পদক্ষেপ 16(1)ত আৰু পদক্ষেপ 15(1)ৰ দ্বাৰা স্পষ্ট নহয়। So it is very much clear, man. He has no possession because he wants eviction. If he is the son of late Shukram Mangra, this is the all are the productions after the death of Shukram Mangra. And moreover, mutation is not the proof of title. Lordship is aware about this.
Because we don't find.
Well, I see no discussion of the witnesses in the judgment. In the first trial court judgment, there is no discussion of their witnesses. So for appellate judgment, now let me say appellate judgment starts from page.
No, had it been no discussion of your evidence, then matter would have been, how can you canvass this? Decree is in their favor, whether they had discussed their witness or not. How is it going to affect you? It is not your witness.
No, actually,
If your witness was
not
ignored,
only mine, not only their witnesses also not discussed.
how did it make it?
From the record, it appears that my witnesses are also not discussed. From the record, as I see, because from 27 it starts, there is no discussion of anybody's witness.
You have discovered this in the court when we had pointed it out.
Yes, that,
You have not taken this as a ground
yes,
even.
that is true, my lord. For that I have lied to my lord.
Heard. The M.A. Mahmood Learned Counsel for the appellants who have preferred this appeal under section 100 of the Code of Civil Procedure 1908 against a judgment and order dated 17/2/2024 passed by the learned district judge Sonitpur in title appeal number 3 of 2021, upholding and affirming the judgment dated 12/12/2018 of the learned civil judge Sonitpur in title suit number 7 of 2015, full stop, by the original judgment, comma, a preliminary decree of partition dated 13/12/2018 and decree for the other reliefs. Whereby preliminary decree for partition and decree for other reliefs dated 13/12/2018 has been passed. Full stop. It is submitted, it is submitted that the findings on the issues, more particularly the issue number 4, is not based on the materials on record and the evidence deduced by the parties have not been discussed. Full stop para. Admit this appeal on the following substantial question of law. Whether the findings arrived at by the learned trial court, which have been affirmed by the first appellate court against issue number 4 on the aspect of the legal heirship are based on the materials on record, including the evidence of the respective parties. Full stop. Any other, Next to any other. Number 2, now any other question? Let steps be taken for service of notice upon the respondents by usual process, steps within 3 working days. Okay.
Hello, right.
Mr. Mahmood, you can take this back. Evidence. 50?
May it please the Lordship, this matter has been listed by order. At the instruction of my senior, I had mentioned the matter, but today morning he is still not well. Therefore, I sought an adjournment. Let the matter may come on Wednesday next week.
Hello, time for the caveat. Today I shall call some minute. So after maybe on.
Senior is not,
Yes,
not well. When?
Next Wednesday, and another prayer is, my lord, in this case, some documents have not been annexed. I may be allowed to file additional affidavit annexing those documents.
Okay. Though this appeal has been listed by order on behest of the appellant, Miss S. Roy, learned counsel submits that her senior Sri B.C. Das is unwell. Full stop. She accordingly prays for an adjournment as well as a liberty to file additional documents in the appeal. Full stop para. Also heard Sri P.K. Deka, counsel for the
caveat.
For the
Respondent 1, 2, 3, and 6.
Respondent was 1, 2, 3, and 6. Who has also filed laws, who has also lost the caveat. Para. The appeal accordingly stands adjourned to Wednesday next. Full stop. In the meantime, the additional documents may be placed on record in the manner prescribed. We can discharge the caveat.
Yes, Lordship.
Caveat Kurus.
Wednesday, 12 June.
Yes, Wednesday, 12 June.
Caveat
Where is the
we-
caveat? Caveat isn't it?
Caveat.
Well, discharge the caveat.
Yes, my lord, absolutely.
Heard the P.K. Deka, learned counsel who has lost the caveat in respect of so and so, caveat or in respect of it. First bill. The caveat would be heard. Caveators would be heard in the event this court proposes to pass an interim order. Caveat stands discharged.
Obliged.
Caveat comes. Your names are shown in the cause list?
My lord, today I have to call some
Okay, okay, doesn't matter.
Yes.
You are with him. Yes.
Next,
So-
please, your lordship. Lordship, the senior constable is out of town. So kindly adjourn the matter for 1 week.
2004 matter. Why is it for orders?
Lordship, he has already submitted the leave application. So when he comes, he will surely attend.
That is not the question we have put.
Sorry, Lordship.
Why is it for orders?
If LCR was repeatedly called for, he's not here, I said.
LCR আহিছে না? দেখা? LCR আহিছে?
In this case, your lordship, the thing is, I am for the insurance company.
Okay. Oh, just a minute, please. Honorable Court, in compliance with the ordinance and requesting for attempt to get it. It has not been sent. What is the matter?
Lordship, in this case, two claim petitions were filed, one in Nagaon by the wife of the deceased, another in Guwahati by the mother of the deceased. In one of the case, they settled the matter, took away the money. Thereafter, the second claim was filed by the mother. The wife had taken the money. Thereafter, the second claim was filed by the mother, and that was the tribunal said that since in one case insurance company has paid, you are not entitled. You have the right to recover it from the widow,
Okay.
and they have come in appeal against.
2004. 2 decades have passed. We'll have it on Wednesday next.
Yes, sir.
We don't need the records. Okay. Office note dated 13/5/2024 reflects that the case records are yet to be received. Full stop. However, taking into account the nature of the dispute, this court is of the opinion that an endeavor can be made for disposal of the appeal on the basis of the materials available, more so when the appeal is pending for the last more than 2 decades. Full stop. Today, a prayer for adjournment has been made on behalf of the appellant on personal grounds. Full stop. As an exceptional circumstances, the matter is adjourned to be listed on Tuesday next. Full stop. This matter would be taken up as the first item amongst the matters for hearings.
May it be please the lordship, as per office number 56/2024, a notice upon the respondent number 3 could not be served due to
Yes,
insufficient.
you have appeared.
Yes, I am for the respondent number 1, but the respondent number 1 is illegally died.
Somebody has passed
Respondent
away.
number 1,
Respondent number 1, in Srimati Ili Devi.
I have to take steps to.
Uh,
But did they that with them? So
I go to LCR.
I collect.
How can I get LCR, sir?
Fine.
It would-
That's all.
go to-
কি হইতো অফিস নোট আছে অফিস নোট কি রয়েছে এইটো হেৰি দিবচোন আৰু চেঞ্জ কৰিব লাগিব who are the councils in the earlier case কোন আছিলে মাত্ৰ Mr. Mukherjee and Mr. Kath Hazarika junior okay প্ৰথম পাৰ্টটো নেদেখিব কি কৰিছিল কি কৰিলো দু অফিস নোট কি আছিল received. Full stop. No. However, the LCR are tagged along with the case records. Topset, কি করে না লাগে এখানে না লাগে না লাগে না লাগে না লাগে না লাগে তারপর হ্যাঁ হ্যাঁ hearing as the appeal is of the year 2004 একটু হেডি বলা গেলে চেম্বার পুরি বলে yes your client whom we have appeared for, she had passed away. You can give her the details.
But I will have to contact that.
Contact and
whether they have
give her
any legal-
details.
Got
I think you are under an obligation also under 10A. 10A, is it 10A? What was it?
10.
Ten A, yes, order 22 rule 10A. Duty of the pleader to communicate.
Got
Your name?
SRA Nasir on behalf of H.
3 S
R.
R S I A.
SRA Nasir.
SRA Nasir, Learned Counsel appearing on instruction of Sri A.J. Sharma.
Yes.
Learned Counsel submits that the respondent number 1 from whom or for whom they were appearing has passed away in the meantime. Full stop. Miss S. Roy, Miss S. Roy, Learned Counsel for the appellant accordingly prays for and is granted 3 weeks time to file application for substitution. Full stop. Sri Nasir may in the meantime give the details of the existing legal heirs who are to be substituted.
Highly.
Oh, LCR is there.
First, there were two cases. One of the LCR is there. Both were qualified. One was filed by the mother, another was by the wife. One LCR is already there.
আরো বদলা বলে ঠিক আছে আগৰটো অৰ্ডাৰে থাকিব অকমান বদলাই দিম বাৰু এইটো দিলে হয় না ওকে Yes.
Please, Your Lordship, in the morning, I've made a mention for adjournment
Yes, yes.
on behalf of L. Gogoi.
Yes, it's for orders. Why is it for orders? Yes, to be undertaken by the petitioner as per not yet been. You have not taken steps, madam.
Okay, we will take fresh steps.
Office note. Anna, seen the office note dated 3/5/2024. Made in terms of the order dated 22/3/2024 of the Learned Lawzima Court. Full stop para. Miss, your name?
Tinlum.
Tinlum, Learned Counsel for the applicant petitioner prays for and is accordingly granted a week's time to take fresh steps for service of notice upon the respondent number 1 by registered post with AD as well as usual process through the office of the Learned Civil Judge Junior Division, Dhemaji. Yes, take steps. 1 week.
On behalf of L. Gogoi.
Doesn't matter.
Obliged, Lord.
Huh? Tinlum. Tinlum. Oh. Yes. Item number?
12 point.
Yes.
My lord,
You're for the respondent.
yes,
Who's for the appellant?
my lord, even on the last day, the counsel for the applicant.
None appears for the appellant applicant appellant on call. Whereas G. Imtiaz,
Yes,
learned counsel is present for the respondents, full stop. Para, even on the last occasion, that is 26/4/2024, none was present for the appellant, full stop. Para, in the interest of justice, a final opportunity is granted to the appellant, directing listing of this case on 14/8, 14/6, next Friday.
highly
Full stop. This court, however, makes it clear that in case of further non-representation, appropriate orders will be passed.
highly.
May I please, Lordship? Lordship, kindly allow us to take persistent proof paper publication, my lord.
You have taken Dusty.
We have taken, my lord, but they are not served, my lord. That's why, my lord.
If you have tried to serve, file an affidavit, we'll deem it to be served.
No, my lord, company wants to serve to paper publication, my lord.
The present IA
Yes, ma'am.
is at the stage of service of notice. Full stop. The the connected appeal along with the IA were filed in the year 2019. Full stop. Para. Ms. L. Sharma, learned counsel for the applicant, has however submitted that in view of the aforesaid position, the notices may be directed to be served by way of paper publications.
On vernacular language, my lord. Assamese.
Para, considering the above, let such notices upon the respondents be served by paper publication, full stop. Such publication is to be made in one issue of the Assam Tribune and another issue of the
Vernacular language.
Dainik Okham, and are to be routed and the notices are to be vetted VTTD by the registry of this court, full stop. Let the next date be fixed on how soon can you get the publication done, madam?
My lord, after vacation, my vacation.
Fixed on 19th of July 2024. And the said date be clearly reflected in the notice to be published, full stop. Prior to the next date fixed, the applicant is also required to file an affidavit annexing the copies of the newspapers, concerned newspapers.
Oblige me.
Item 14.
It is the lordship. Lordship, we were supposed to take justice service on respondent 2 and 3. We have taken for 2, lordship. 3 is from Manipur. That report we haven't yet received. That's why we couldn't file the affidavit, lordship.
Okay.
So we need 4 weeks time.
Okay. MSRD Mazumdar, learned counsel for the appellant, submits that so far as the dusty service upon respondables 2 and 3 is concerned, the respondent number
2's dusty report we have got.
respondent number 3 being from the state of Manipur, the confirmation report is yet to be received. Full stop. The learned counsel accordingly prays for and is granted further 3 weeks time to obtain necessary instructions / file affidavit in this regard.
Highly obliged, sir.
May I please, your lordship?
Yes.
I need, my lord, 1 week time to file the petition of respondent number 3, my. He has died, my lord. Earlier, the council of respondent number 3 informed for this honorable
But
court.
that was in
My lord.
December 23.
My lord, yes, my lord. My lord,
You
we are late.
abated in the meantime.
My lord, we are late to collect the details. Already we have received, my lord. By next Monday or Tuesday, we will file, my lord.
The order dated 19/12/2023 reflects that the opposite party number 3 had passed away in the meantime. Full stop. Para. Sri T. Sheikh, learned counsel for the applicants, however, submits that steps are yet to be taken. Full stop.
By next week, we will file.
Steps are yet to be taken and prays for some more time. Full stop. Para. Matter is accordingly adjourned by further 2 weeks.
Lordship, office noted 5/6/24, LCR have been received. Kindly fix the hearing.
Notice is served.
Lordship,
Okay. Which office note, madam?
5/6/2024.
Your name?
A. Hussain.
Ms. A. Hussain, learned counsel for the appellant has submitted that learned counsel for the appellant, by referring to the office note dated 5/6/2024 has submitted that the lower court records have been received. Full stop. Para. The order dated 9/11/2022 has already recorded the service of notice upon the respondents. Full stop. Para. The matter may accordingly be listed for hearing in its turn.
Made preserve. My lord, this is the matter relating to the violation of.
Oh, yes.
Yes. So. My lord, I think it's high time that this should see the finality. Lordship.
Nothing has happened in the meantime.
Sorry?
Nothing has happened in the meantime.
No, nothing. Nothing. Well, what I find is, they know it well.
When Mr. Mahanta is there, we thought that matter would be.
Well, the Lordship, we tried, Lordship tried, but nothing transpired.
Somebody must be preventing you in trying.
Well, probably their own mindsets. Because when it comes to.
One trust from your side, I think will bring the matter to an end.
Well, provided.
Some advice.
Provided other side is not in my touch matter, I cannot.
That too, Mr. Roy is always accommodative.
So, the way things moved when we met and we at your lordship initiative, that of course didn't result. Therefore, I am not that hopeful, but nonetheless, Well, always it is advisable, more particularly in a case of given nature.
Yes, the case is for contempt. It's not for substantial rights.
Yes.
He has it for any
And
substantial
they are-
rights. We adjudicate, we come to a conclusion.
Yeah.
Contempt, the conclusion may not be very palatable to either of the parties.
Exactly. It can go anywhere, but then it has to be ultimately, well, let the trust out to give a final warning to the sides that, look, this is how the law operates. That is the
Now, what about
ultimate-
little you remember, they had set up some defense that this is not the correct interpretation, or the allegation is not based on correct factual position. It's some parking, isn't it?
Yes, yes. Well,
That
the
corridor.
corridor.
That
The
is
common
in
passage.
respect of a common passage.
Common
The
passage.
common
What
passage.
is common passage that has been mentioned in the suit, Schedule D. So your lordship has to see that whether it's a violation of common
know.
passage or not.
That is what your lordship ultimately wanted to know.
What has happened to the main case?
It's
Somehow or other, it is not reaching that stage. So that it can be finally decided.
Why don't you
Because
insist?
they have got the absolute result, absolute benefit they are enjoying.
No,
So they are not interested to go ahead with it. My instruction
no,
is,
no, no. That is absolutely
my
wrong, my lord.
instruction is this.
No,
That is absolutely wrong.
the subject matter, the main lease is still pending. This is an offshoot, a very minor offshoot of a
That should have
contempt.
proceeded. Yes, that should have proceeded.
You
But
proceed
on
and you
some
find.
more, ultimately, can you see the situation? The plaintiff has already got the relief which he wanted. He's rather enjoying it by misinterpreting the order of the Supreme
what the-
Court, by violating the
Let him
undertaking
prove, my lord,
given
that
by
it is
him.
Now, what is the stage of the suit?
You
So,
know, evidence is not started, yet.
evidence will start.
Evidence has not started.
Not yet.
Why? Suit is of which year? 19, I think. Or 18. Is it 18 or 19?
18, yeah? 15. Suit of 15.
Why evidence has not started?
I don't know, my lord, because let me, I'm taking instruction.
My instruction is that on some ground or other, steps have been taken, not proceeding. Civil suit, so many formalities, so many things, so many questions raised at times. They are taking and the interest is, I am only suffering. I have been prevented. I am not, I am.
Now we'll direct this suit to be completed. Brought to its logical conclusion within a time-bound frame.
Yes, a time frame may be given, my lord.
By that time, well, till kindly see the order of this honorable court, till today, I am obeying my own commitment. This is a commitment given by us, both sides, but they have not. They have misinterpreted it to an
Now,
extent.
okay, now tell us to you whether you're pressing on this today hearing, not today, immediate hearing, or you want to avail some more.
Well, my instruction
I'm
is
leaving it to you because it's an old matter. Every time
old
you
matter,
cannot
but
just.
every time it is coming.
It's not a question of
Lord,
passing the buck.
I
Somebody will
want-
have to take the burden. We either we or some other.
Exactly, well, I want that, man.
Your lordship will decide the issue, my lord. That we are on that.
Whether there is a contempt or not.
Yes,
But may hear it next week, anything.
even that is very short
Or
time, my lord.
even today. if
Even
your
today it
lordship-
can be
Today,
completed.
today we'll rise slightly early. So there are
Oh,
some
yeah.
administrative works.
Yeah.
Today it may not be possible.
Let it be on Tuesday then, my lord.
Tuesday, many matters have been fixed.
Wednesday,
We can
my
have it on Wednesday.
Wednesday, my lord.
Wednesday পারা যাবে না না একটু না জানিব দেখা আইডিয়া আছে নি Wednesday বহুত ম্যাটার ফিক্স করা আছে Wednesday
This will not take much time, my lord.
Not take much time. Almost.
that is your perception.
So we'll try, we'll come.
On the
I'll take Miss.
we have had preliminary hearings of this matter.
Yes,
It
yes.
went 2 hours,
2-3 occasions.
2-3 occasions.
My lord, I'll say that I will take my lord, hardly my lord, 20 minutes, my lord.
Lordship is aware about the facts. That's the positive aspect. Now we'll place the remaining part, including the law. Touching upon the conduct of the parties, that is the main thing now. For me,
Conduct already,
me.
Leonard single judge has said, my lord, what is the
For
conduct
me.
of the parties?
for me, my obligation is to place
One has.
the whole thing involving the conduct, how they are behaving. So let's see what way it goes.
Yes, Wednesday, my lord. Lordship will upgrade the matter, my lord, at 2 o'clock.
This is not a very important matter that
Well, I
needs
know.
upgradation.
I know, but
But until
Two parties fighting for a passage corridor.
my
And,
lord, the
and
passage is my lord, the front portion is a common passage. And my land, my place is not a common passage. That has been defined Schedule D in the title suit, my lord. One cannot go beyond that, my lord.
well, all said and done, ultimately lordship will have to.
now what is your difficulty now? You have difficulty in parking your vehicle.
Yes, I am
Even now?
outside. Well, I am out. I am on the main road. I am on the main road. He is enjoying. His initial suit was that it is me who is preventing. Court said-
Are you planning to make the main road a part of your compound by kind of adverse
Had it
position?
been possible, probably by now he would not have left the opportunity.
Since how long are you parking your car there?
From the order of this honorable court.
You have converted into a garage.
The suit is, we filed a violation of injunction, my lord. That is pending for hearing that injunction application. And secondly, we filed amendment of the suit.
No, did you,
And that-
when you had said, was there any sincere effort in resolving
There
this
was
kind of,
a-
these are very trivial issues.
Let me place the fact, my lord.
Parking of vehicles
No,
and
let me
corridor
place the fact, my lord.
and the
two
status of
sides-
the parties involved doesn't look good. You
Yes,
have come up in
that's
a
correct, my lord.
contempt and we are
We
deciding
have
a contempt.
Lordship will see the correct fact, my lord. The property, two friends bought it in
No,
front
we are not going into the merits.
and on the backside of me.
Wednesday we'll try.
That's
On the
correct.
Thursday one.
But,
On Thursday.
Thursday.
Wednesday I have some.
Thursday we'll try, but we'll not give preference to this matter.
Well,
We will not give.
lordship will at least see that.
We'll treat this as a matter as a normal matter, and
That's correct, my lord.
it's not a
We
matter of
cannot
interest.
claim by that way.
Matter you should sit and settle. Very small issue.
Small issue, my lord.
Some little bit of give and take. What else is required? Okay,
Well, certain measures were suggested by media so that court can adjust.
I think we had an in-camera proceeding also.
Yes. But my learned friend's client is not agreeing to it.
No, lordship, once the lordship delivering the order, then lordship, what happened? I don't have to explain that.
Okay. As agreed to by the paucity of time, may not allow the matter to be considered properly. Full stop. Para. In the as agreed to by the parties, list for consideration on Thursday.
For further consideration, lordship.
Further, we have not said.
Lordship 13, my lord. I'll be out session, my lord. On 12, my lord.
Well, Wednesday, Mr. Mohanta has some difficulty, I think. 12, is it possible, Mr. Mohanta?
Let us try.
12.
12.
Yes.
12. Okay, 12.
Oblige.
Because I am having some burden.
Okay, we'll accommodate, no
Yes.
problem.
Oblige.
Lordship will pay his office note dated 1/12/23.
112.
Yes, Lord.
Yes, please.
We were supposed to serve notice on respondent 5. Unserved notice insufficient address. So Lordship may allow us to make dusty service, Lordship. Because only for 5 it is waiting. This Lordship.
MS R.D. Mazumdar, learned counsel for the applicant, who by referring to the office note dated 1/12/2023 has submitted that dusty service may be permitted upon the said respondent number 5, full stop para. You are for?
Respondent number 4, Your Honor.
And other respondents served, madam?
Other respondents served, Lordship.
Okay.
1 to 4.
Para, having considered the aforesaid prayer has been considered, full stop para. Liberty for serving dusty, for serving notice on the respondent number 5 by dusty is allowed, which is required to be routed through the registry of this court. Let the next date be fixed on, we'll have it on 17th of July, 2024. full stop. In the notice accompanying the dusty comma, the next date is to be clearly reflected, full stop. The applicant is also required to file an affidavit prior to the next date regarding dusty service.
Mr.
Chaudhary, for which matter?
I'm waiting for one matter.
Order matters.
Order. Actually, my lord, we have prayed for little clarification of an lordship's order. Item number 38 and 39. If today it is, it can't be done Monday, can I?
Today we'll rise at 4 o'clock. But who is for the other side?
Other side, state government, my lord, forest department.
State government, what review matter?
Not review, my lord, small clarification of.
By
the
this court?
Yes. That, my lord, I mean, that forest matter, Nameri matter. Well, there is a confusion has arisen. Your lordship has interfered with the impugned action and has said the interim order was made absent.
Okay.
Now, interim order was only 10 persons were permitted to enter. Now they are interpreting the order that it amounts to only 10%. Whereas our entry itself was prevented. That is the clarification.
If the other side is there, we could have, or maybe some other day.
On Monday, my lord, if it is not.
Monday, very difficult.
All Wednesday, my lord.
But we can try on Wednesday.
Yes, Wednesday.
Any state council here who can inform, who is appearing otherwise?
Huh?
Oh, forest department,
Yes,
department, anyone? Forest
Mr. Gogoi was there. I say. Whether
the judgment, I think, pretty old, I think.
yes, but sometimes because now
No
we
appeal
have,
has been preferred.
now no, they have no appeal has been preferred. In fact, my lord, pursuant to lordship's order, our the arrangement was terminated. Then the learned single judge made an observation that you get a clarification, then it will be everything will be okay. That is how we are prepared.
What has been terminated?
Original agreement between us.
Okay, that is the subject matter of challenge.
That other report.
But how will it have effect in your present fresh writ petition?
No, I think the honorable court was of the view that if this matter is passed out, then it will become easier. Because they are preventing our entry is being prevented.
Mr. Botakur, yes, you have instructions today or Wednesday. If you are equipped with the instructions, we can. Otherwise on Wednesday we can have. You will appear or who will appear?
Lordship, I'll appear. Instructions are not there as such, but the petition we have filed an affidavit.
You have filed objection?
In the main petition.
In the main writ petition.
No, we're not on that. He is seeking a clarification regarding the interim order which allowed 10 persons. Now, the contention is that since the entire action has been interfered with, that restrictions will become, that was the interim restriction.
Yes.
Now that.
Taking advantage of that, that order has been passed. That's why the other thing is.
Which order has been passed?
If your lordship would kindly permit me, please take the IA number 1156.
Order of allow only 10.
Yes.
Item, page?
Page number 81. It starts at page 80. Please come to page 81. Para 8.
Yes.
It is crucial to note that Honorable High Court did not issue any mandamus permitting petitioner association to resume its activities in EcoCamp, except for the interim order which was made absolute indefinite. And they're taking advantage of this. The interim order stipulated that in the meantime, respondent number 4, that is so-and-so, shall allow entry of 10 persons authorized by the President and Secretary of the Association to the camp area with specific
That was at the time when were in season of the matter, when we thought that we'll examine. Now the
end of the
examination
matter,
has been done.
the very offense report has been interfered with. That means
Examine the matter has been dealt with, interfered with.
So because that line is there, interim order is made absolute, that is why they are taking advantage of. And your lordship's observation is at page 17.
And then, thereafter, what has happened?
Now, my lord, when we challenge this order, this particular order of 12/6/23, then during the course of hearing, this aspect has come out. Therefore, the honorable single judge was of the view.
Okay. Oh, this is the subject matter of challenging another case. Okay. Mr.
Therefore-
Bhattakur, what do you say?
But if the proceedings have ended, the earlier statement.
No, see, if this view of ours been tested in any higher court and matter would have been reversed, or even at pending, then matter would have been different. Now we have passed a final view in the order dated 33/2023, and the impugned actions have been taken, have been interfered with. Now, can you construe the last part to mean that no, only it will be restricted to 10? I don't think that will be a correct interpretation. I think we'll modify this. Third, K. N. Chaudhary Leonard, Senior Counsel for the applicant also heard Sri I. Bhattakur Leonard, Standing Counsel Forest? Standing Counsel Forest for the opposite parties, full stop para. The instant application has been filed in connection with WPC 3745 of 2021, which was disposed of on 33/2023. Full stop. Para. Sri Chaudhary Leonard, Senior Counsel, has submitted that while the aforesaid judgment and order, the action of the respondents in the form of an offense report number CH35, whereby the members of the petitioner association were termed as accused qua offenses under sections 24A bracket में capital A, comma 24B capital B and 25 of the Assam Forest Regulation 1981 and articles and under articles small 2A, page 67 से लिख लीजिए, comma and 3 capital B of the Forest Conservation Act 1980. Full stop. This court, by the aforesaid judgment, has interfered with the impugned action and has held the same to be unsustainable in law and was set aside. Full stop. While disposing of the writ petition, comma, the interim order was made absolute. Full stop. Para. The London Senior Council has, however, by referring to a communication dated 12/6/2023, has submitted that the department has taken a view that since by the interim order, only 10 persons were authorized, no, 10 persons who were authorized by the association would be allowed to enter, comma, enter the area in question, comma, the same restrictions are being imposed, full stop. Para. The Senior Council has also submitted that the aforesaid action has been put to challenge separately in WPC 488 of 2023, wherein an order, wherein an observation has been made to seek clarification on the aforesaid aspect, and accordingly, the present application has been filed, full stop. Para. The maintainability of an IA in a disposed of petitions is no longer res integra, full stop, though a fresh cause of action cannot be raised by filing an IA in a disposed of matter, comma, clarifications can be sought for, as has been held by the Honorable Supreme Court in the case of A.S. Ansari versus Indian Airlines. What was the name? Ansari versus Indian Airlines.
Yes.
And what was the earlier case?
Even that
Brahmadat,
that was a subsequent cause of action, para 10.
Brahmadat has been explained, but
Yeah.
Ansari, full stop. Para. This court is of the view that when the entire impugned action was held to be unsustainable in law and set aside by the by the judgment and order dated 33/2023, comma, the observation that the interim order be made absolute cannot be given a restrictive meaning of allowing only 10 members, 10 persons to enter into the area in question, full stop. Such restrictive meaning would be against the direction contained in the judgment and order dated 33/2023. Full stop. Accordingly, comma, the matter stands clarified that the direction which was given in the form of an interim order stood merged with the final order, and the entire action of the respondents being held to be unsustainable in law and set aside, comma, the applicant would be allowed to have all the benefits of such pronouncement of this court. I accordingly stands disposed of. What is the other one? 1336.
Oh, there are two writ petitions, my lord. Same.
The writ petition will be different, number will be different. 1336, same, huh? WPC alag hoga isme.
There were two writ petitions, so there was a common judgment.
WPC will be 614 of 2021 isme. 1336. Okay, both will be allowed. All right, Adina lage. Rest, today we have to have some works. Today, except any matters which are very urgent. Rest will give dates.
Lord,
Yes.
Item number 23, Lordship, landlord tenant matter, that other side has appeared, maybe fixed for admission, Lordship.
We'll give dates, don't worry. Any matters where interim order is still today?
Madam, item number 58, Madam, it is urgent.
What is the matter about?
About it, there is a probate has granted, arising out from the partition suit. Partition of one of the, during pendency of the suit, probate was, will was executed.
Your Lordship, I am for a opposite party. We'll file the affidavit in opposition.
Well,
Because
file it and file it soon.
We'll file because
But
we have
he is,
received on 30th of May, 35.
okay, he has just entered appearance. Let him file the affidavit.
Let us file the affidavit.
Okay. On a item number,
Item number 58.
on a request made on behalf of the respondents, matter is adjourned by 2 weeks
2 weeks.
to enable filing of affidavit in opposition.
Oh, bless.